sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
Thank you to all of my patrons, members, and supporters. You are the reason that I am able to upload new bond courts daily. All members and patrons receive access to the bond court Discord server. Please send me a message on Patreon or leave a comment on YouTube if you are unable to join the server. Thank you all for your support.
All right, good morning. This is Judge Cameron. We have this morning initial appearances. Why don't we invite all the potential witnesses in the hall? We have present Ms. Fleming, the Assistant State Attorney, and then do we have Ms. George present here or at the jail? Good morning.
Good morning, Your Honor. I'm at the jail.
All right. So the first one I have is Diego Stalin Tavares Fleury.
Spanish.
Can we do the Spanish? Can we do the Spanish at the end?
You're gonna do the Spanish at the end, Your Honor?
How many Spanish interpreter cases do we have?
We have 2 on the first session.
He's calling now.
Sorry?
We have 6 on the second session, 2 on.
6 on the session. All right. Boy, I've got a lot of folks in here today. Is that going to be problematic to do the interpreter cases last, or should we do them now? Do you have a preference?
He's calling her now.
Good morning, Your Honor. Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
All right. Good morning. All right. This morning we have Diego Fleury. Are we going to do this with headsets, or are we going to do this out loud?
With headsets, if possible.
Okay. Y'all have headsets to where you're at?
No, sir, not down here.
Okay.
I'm sorry, Your Honor. Give me 1 second, please.
All right. No worries.
Your Honor, I'm going to have to do this over the PA. The way I received the call from the courtroom, it's not allowing me to make connection to the podium.
Okay. Can they hear you there?
I'm on the PA, so.
Yes, sir, we can hear fine.
Okay. All right. All right. Good morning, sir. Tell me your name, please.
Por favor, indique su nombre.
Diego Tavares Fleury.
I only can hear Diego Tavares, and then the last name I couldn't hear. Repita otra vez el segundo apellido.
Diego Tavares Fleury.
I'm sorry, Your Honor. I'm sure you can hear it better than me. I cannot distinguish it enough to repeat it.
I can hear Diego Tavares Fleury. Mr. Fleury, you're charged with trespass on property after warning.
Señor Flores, a usted se le acusa de entrada ilícita en propiedad ajena después de haber sido previamente apercibido.
I'm going to find probable cause.
Determino que existe suficiente indicios de criminalidad.
I'm going to stay the bond at $500.
La fianza se mantendrá en $500.
Mr. Fleury appears to already be out on conditions on 2 other charges.
El señor Flores ya se encontraba libre con 2 acusaciones.
And those appear to be petty theft and possession of drug paraphernalia.
Y parecen ser que uno fue hurto de menor cuantía y el otro tenencia de artículos de droga.
I'm going to take no action on those other pending cases.
Por lo tanto, no se tomará ninguna acción con respecto a esos otros casos abiertos que tiene.
Mr. Fleury, would you like me to appoint a public defender?
Señor Flores, ¿desea usted que yo le designe defensor público?
Would you like me to appoint a lawyer to represent you?
¿Quiere usted que le designe un abogado para que le represente?
Sí.
Yes.
All right, I'll appoint the public defender's office to represent Mr. Fleury. Thank you, sir.
Muy bien, se le designará defensor público para representar al señor Fleury. Gracias, señor. Your Honor, may the interpreter have the case number for this gentleman?
You absolutely may. It's 2022 MM 3897 AO.
Thank you.
All right, next we have Morales de Leon Hernandez.
Morales de León Hernández.
Your Honor, we also have a victim here who also speaks Spanish.
Okay.
Señoría, tenemos aquí una víctima que solo puede hablar español.
All right,
Your Honor, I figured out, I'm sorry, I do apologize, it was my mistake. I didn't realize you were in 7 Charlie. I can establish connection with the 7 Charlie if you need me to for the victim.
okay. All right, great. All right, we have a witness here. All right, do you need a moment, Madam Interpreter?
Your Honor, I think it's because of the whole special system that we've established in that courtroom. I cannot make connection with the podium either, so I will do it all over the PA.
Okay, all right, we'll take our time. This is the only second one we have this morning, so we're in good shape. All right, would you raise your right hand to be sworn, please?
Señor, por favor, levante la mano derecha para prestar juramento.
All right, do you promise to tell the truth, the whole truth, and nothing but the truth to help you?
¿Promete usted de decir la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
All right, good morning. Tell me your name, please.
Buenos días, indique su nombre, por favor.
Ovidio Alexander Yokbamaka.
Despacio, otra vez.
Ovidio Alexander Yokbamaka.
Ovelio Alexander Yokbamaka.
All right, I have Mr. Jacques Alexander as a second defendant on this paperwork. That can't be right.
En esta documentación tengo al señor Jacques Alex como el segundo acusado en esta documentación. Eso no puede ser cierto.
I believe it was a scrivener's error, Your Honor.
Creo, su señoría, que fue un error tipográfico.
All right, well, if the state is acknowledging that Mr. Jacques Alexander is in fact a identified victim, is that correct, Ms. Fleming?
La Fiscalía está reconociendo que el señor Jacques Bamaka es la víctima señalada aquí en esta causa.
Yes, Your Honor.
Sí, su señoría.
All right, sir, would you tell me your relationship with the defendant, Morales de Leon Hernandez?
Señor, ¿me podría usted indicar cuál es la relación que tiene usted con el acusado Morales de León Hernández?
Ella es mi novia.
She is my girlfriend.
Okay. I see you have a child with you today. Do you have a child together?
Veo que usted trajo un menor aquí hoy día. ¿Acaso tienen ese menor juntos? ¿Ustedes los tuvieron juntos?
Sí, es mi hijo con ella.
Yes, it's the son I have with her.
Okay. And do you reside together?
¿Y residen juntos?
Perdón, no le entendí.
Residen juntos.
¿Que vivimos juntos?
If we live together?
Yes.
Sí.
Sí.
Okay.
Yes.
Okay. My Spanish is getting better, Madam Interpreter. I understood that one. All right. Mr. Jacques Alexander, my job today is to make a determination as to whether there is probable cause to believe that Ms. De Leon Hernandez has committed a crime.
Señor Jacques Bamaka, el labor que tengo aquí hoy día es determinar si existen suficientes indicios de criminalidad para pensar que la señora De León Hernández cometió un ilícito.
I am going to make a finding of probable cause.
Emitiré un fallo de indicios de criminalidad.
My second job this morning, sir, is to make a determination of what conditions of release I should impose to protect both you and the community from your girlfriend.
La segunda labor que tengo aquí hoy día es determinar las condiciones de libertad que se van a imponer para protegerle tanto a usted como a los demás en la comunidad.
Those conditions could include my ordering that she have no contact with you or that she have no hostile contact with you.
La condición puede ser que esté ella prohibida tener ningún trato hostil con usted o no tener ningún trato en absoluto con usted.
So first, my question is, what do you want me to know as far as a determination as to whether the defendant should be permitted to return to the home that you share?
Entonces, la primera pregunta que le tengo a usted es, dígame qué piensa que yo debería de saber con respecto a el fallo que tendré que tomar si permitiré a ella regresar al hogar que ambos compartían.
Do you want her to come home or no?
¿Quiere usted que ella regrese a la vivienda, sí o no?
Sí.
Yes.
Are you afraid of any future violence if I permit her to return home?
Y si yo le fuera a permitir a ella regresar a la vivienda, ¿usted tiene miedo de que ocurran futuros actos de violencia?
No.
No.
All right. If I do not let her return to your home, does she have another place to stay?
Si no le permito a ella regresar a la vivienda, ¿acaso ella va a tener algún otro lugar donde se pueda quedar?
La verdad no sé.
I honestly don't know.
Okay. All right. All right. Ms. Fleming, on behalf of the state, do you have any questions for Mr. Jacques Alexander?
Licenciada Fleming, por parte de la Fiscalía, ¿tiene alguna pregunta que le desea formular al señor Jacques Bamaca?
No, Your Honor.
No, su señoría.
All right. Ms. De Leon Hernandez, having found probable cause to believe that a crime was committed.
I'm sorry, Your Honor, could you finish the thought, please, for the interpreter?
Sure. I'm sorry. I am going to set bond in this case in the amount of $500.
Muy bien, señora De León Hernández. Habiéndose determinado que sí existe suficientes indicios de criminalidad para sustentar que se cometió un ilícito, se fijará la fianza en $500.
I am going to permit you to return to the home that you and your boyfriend share.
Voy a permitir que usted pueda regresar a la vivienda que compartía usted con su novio.
Conditions of your release are to include that you not have any hostile contact with your boyfriend, Mr. Jacques Alexander.
Las condiciones de su libertad incluirán que usted esté prohibida tener ningún tipo de trato hostil con el señor Jacques Alexander, su novio.
I have jurisdiction over you, but not over him.
Yo sí tendré jurisdicción sobre su persona, pero no sobre la de él.
Should you behave should you behave in any way that causes your boyfriend to feel as though you are being hostile toward him, all he needs to do is contact law enforcement, and your conditions of release will be revoked, and you'll spend the rest of your time in jail until this case is resolved.
Si usted lleva a cabo alguna acción que le hace pensar a su novio que usted ha tenido trato hostil con él, lo único que tendrá él que hacer es comunicarse con las autoridades y entonces las condiciones de su libertad serán revocadas y se encontrará usted pasando el resto del tiempo en la cárcel.
I'm also going to order that you consume no alcohol, possess no firearms or weapons.
También le prohibiré a usted consumir ningún tipo de alcohol, lo cual también le incluirá la prohibición de armas o armas de fuego.
Did you want me to appoint a lawyer to represent you?
¿Desea que yo le designe un abogado para que le represente?
Would you like me to appoint a lawyer? ¿Sí o no?
Señora, ¿quiere que le designe un abogado? ¿Sí o no?
Yes, Your Honor.
All right, I'll appoint the public defender to represent you. Good luck.
Muy bien, le designaré defensor público para representarle. Buena suerte a usted.
Thank you, sir.
Your Honor, may the interpreter have the case number for Ms. De Leon?
You certainly may. That is 2022 MM 3966AO.
Thank you, Your Honor.
Are those the only Spanish cases we have for the morning's docket? All right, thank you, Madam Interpreter. Have a good rest of your day.
Thank you, Your Honor, and I apologize for my confusion with the connection. Thank you.
No worries. Thank you. All right, next I have Julio Julian Acosta Diaz.
Case behavior, Your Honor.
Okay, we'll pass that case then. Will that be reset for tomorrow for Judge Bigney?
I will waive the appearance, Your Honor.
Okay.
Gentleman that was just up here, is he waiting for?
All right, next I have Amy James.
She refused, Your Honor.
All right, we'll pass that.
Your Honor,
Yes, ma'am.
I will waive the appearance. They were already reset from yesterday, so I will waive the appearance, Your Honor.
All right. So waiving her appearance, I will find probable cause bond on the charge of possession of drug paraphernalia is stayed at $500, and she's currently apparently out on bond on a charge of possession of cocaine and possession of drug paraphernalia for which she was ROR'd.
I would just add, I'm trying to verify that the state did move forward and file charges, Your Honor.
Okay.
Your Honor, state has not filed at this time. State requests no action.
I will take no action. You're making my job easy for me. Thank you, State.
What was the reason? Medical?
Refused. She did not want to see us this morning. Ms. George, do we need to revisit? Did I go too quickly over Mr. Acosta Diaz? Did you want to waive his presence and also have me address PC and Bond?
Yes, Your Honor.
Yeah, we're going back in time. Sorry.
You got it.
I was a little too fast there. All right, so Ms. George is here on behalf of Mr. Julio Julian Acosta Diaz, who has waived his appearance. He's here on a charge of carjacking, grand theft, third degree, motor vehicle, and tampering with physical evidence. Ms. George, did you want to be heard on any PC?
Can we, because everything is moving really slow for me, Your Honor, I'm sorry. Can we recall this one after the next case? I'm trying to pull it back up.
Sure. All right. Next, I've got Pedro Pachado Jr. I have that Mr. Pachado Jr. is here on a warrant. Is Mr. Pachado there?
Yes, Your Honor.
Okay. It looks as though this is a warrant signed by Judge Dubois. Based upon the warrant, I'm going to find probable cause. I'm going to stay the bond at none and appoint the public defender's office.
Your Honor, to be clear, that's on the 661 case number.
Let's see.
Got two cases.
Yes, two cases? Well, thank you for the copy is very difficult to read, so thank you. That's on, looks like 2022 CF. Is it 6586? I feel like I'm at the eye doctor. All right. And then, there it is, 6586. Oh, and then here's the next one.
6661.
Thank you. All right. The next one is 2022 CF 6661, charge of robbery with a firearm and aggravated assault with a firearm. This is also on a warrant signed by Judge Dubois. I'm going to find probable cause based upon the warrant. Bond is currently set at none on the warrant. Ms. George, did you want to be heard on conditions of release?
Your state would ask you to set no bond on count one, the robbery with a firearm, as it is a PPL.
Right.
For another hearing at a later time. However, state does request that you set a bond as to count two, the assault with a firearm, as he is otherwise entitled to it at this time, with a no contact and a no return with the victim.
All right.
And,
George?
I agree, Your Honor.
All right. Ms. Fleming, any thoughts? I know one count is no bond, so that may be determinative as to whether the state, what charges the state files, but did you have a thought on the bond on ag assault with a firearm?
Your Honor, they would ask for $5,000. He doesn't have much of a history.
I was thinking the same thing. All right. So I will set no bond on count one, robbery with a firearm, set bond in the amount of $5,000 as to count two, aggravated assault with a firearm, special conditions of release should Mr. Pachado be released. He's to have no contact with any co-defendants, no weapons or firearms. State, were there any other conditions?
State would ask for a no return, Your Honor.
All right, no return to the scene. Judge Dubois indicating in his warrant surrender all firearms and ammunition to the sheriff within 24 hours of release, so we'll impose that as well. So, Madam Clerk, no return to the scene, no possession of no weapons or firearms, surrender all firearms and ammunition to the sheriff within 24 hours of release, and no contact with witnesses or co-defendants. And I think that is both of Mr. Pachado's charges. Next, I have Umberto Vasquez.
And, Your Honor, whenever you're ready, we can recall the other case, Mr.
Okay, would you like to do that first?
Yes, Your Honor, if we could.
All right. Julio Julian Acosta Diaz.
And Your Honor, I would argue no PCS to the carjacking. Based on the arrest affidavit, it stated the victim could not identify my client, and the only other thing that we had was that he may have been in the vicinity within that time frame, and I would just argue no based on that alone, Your Honor.
All right, state PCS to carjacking on Julio Acosta Diaz. This is 2022 CF 6785AO.
Yes, Your Honor, this was reset yesterday, also due to PC for the carjacking. The ASA was not able to obtain another affidavit. However, it's only been 24 hours. The state asked for an additional 24 due to the level of offense of the felony. And so it's entitled to up to 48, so state would ask for the additional 24.
All right, I'll roll this to tomorrow. I'll give the state an additional 24 hours to perfect probable cause on the charge of carjacking. Since I'm doing that and Mr. Acosta Diaz is not going to be leaving within the next 24 hours, I'll take no action on the other two bonds, and I'll let Judge Bigney resolve all that at once, unless the state or the defense would prefer me to set bond on the other two. I think the carjacking is the more serious and may control what bonds are set or conditions are set on the other two. State, any objection by rolling the whole thing to tomorrow?
State has no objection, Your Honor. State also has no objection since it didn't come in as carjacking on the firearm. He is entitled to a bond on it. So state has no objection to go ahead and setting a bond in case he wants to bond before state will provide PC. Otherwise, he can wait.
All right.
Right up to Your Honor.
All right, Ms. George, what would your client prefer to do? Stay, wait to see whether the state can perfect probable cause on the more serious charge, or have me set bond now?
Your Honor, I'd ask that you set bond now, and if he can't afford the bond, then he'll be brought back here where we can address the probable cause issue.
Okay, all right. I'll set bond on the armed carjacking in the amount of $10,000. Grand theft third degree motor vehicle, $1,000. tampering with physical evidence, $1,000 for a total of $12,000. And roll the case to tomorrow to readdress the carjacking charge on PC.
Your Honor, we're going to keep the other cases at the same bond amount that Judge Calderon imposed. He gave bonds for the other charge. For the
And the
other.
other two, yeah, they'll be stayed at $1,000 each. Those were the charges, the bonds that were set by Judge Calderon. All right. Next I have Umberto Vasquez.
Yes, Your Honor.
All right. Mr. Vasquez is here on a charge of burglary to an occupied structure, possession of burglary tools, and criminal mischief.
I believe this was another reset, Your Honor, for probable cause.
Okay, on the burglary to an occupied structure?
Yes, Your Honor.
All right.
It says on the affidavit, I was trying.
All right, State, did you want to be heard on PC?
Yes, Your Honor, the state was not able to obtain another affidavit for the burglary. However, the state would just make the argument that it is present within the PC that we have. Arguing that the defendant entered a structure under possession of the victim. In this case, I believe he was in the curtilage. He was going through the fence. At the time of entering, he had intent to commit a crime. He was arguably in this one committing a criminal mischief by breaking the fence and having burglary tools. They would argue that that's enough at this time for probable cause on count 1.
Okay, and the occupied structure portion of the burglary?
Yes, Your Honor, I do believe it says that the victims were on scene, Law and Olbajan. I'm sorry, I'm butchering the last name, Olabajano. They saw him trying to cut through the gate on the camera within the building, and they ran and got on the golf cart and intended to stop him.
Okay, all right, Ms. George, your response?
Your Honor, yesterday my client was seen, they found no PC. Allegedly, he was cutting the yard at the time of this alleged incident. And because the state was given an additional 24 hours to perfect PC and they did not, Your Honor, I would ask that my client be released ROR in this case.
All right, based upon the charging affidavit, I do find that there's a PC for the charge of burglary, but not to an occupied structure. So I'm going to find PC for the lesser included of burglary. I guess that would be an unoccupied structure. I'll set bond in the amount of $2,000. I'll stay the bond on the possession of burglary tools at $500 and criminal mischief as to $500.
And Madam Clerk, I'm getting that statute for you.
Thank you, State. So I show that as a total of $3,000. My math is correct.
And they asked for a no return and no contact, Your Honor.
No return, no contact. No return to the location of the offense. No contact with any of the witnesses for the state.
Thank you, Your Honor.
All right, welcome. All right, good luck.
Thank you. Yes, sir. Thank you.
All right, next I have Jacques Albrecht.
Yes, Your Honor.
All right, I've reviewed the charging affidavit. I find probable cause of the charge of aggravated battery with a deadly weapon and domestic violence battery. I'm going to set bond on the aggravated battery. Do we have? Oh, hello. Good morning. I figured that out a little too late. Madam Clerk, would you go ahead and swear these witnesses and all the other witnesses that are here? So if you're here to testify this morning, would you please stand, raise your right hand to be sworn by my clerk? If you're anywhere in the courtroom, in the sound of my voice, then stand and be sworn. Thank you.
Do you swear or affirm the testimony about the leadership of the truth, the whole truth, and nothing but the truth?
Yes. All right, you may all be seated. All right, young man, tell me your name, please.
My name is Jacques Albrecht.
Okay. Mr. Albrecht, you are the brother of the defendant, is that right? And who you brought with you this morning?
My mom.
Ma'am, tell me your name.
Jacqueline Albrecht.
All right, let me start with, Jacques, how old are you?
I'm 16.
16 years old, all right. Let me talk to your mother for a moment. Ma'am, you may have heard me explain earlier this morning. It is my job to both determine whether there's probable cause to believe a crime has been committed. I find there is probable cause for these two charges. The other job that I have is to determine what conditions of release would both protect the community at large and your son and yourself from any future danger from Jacques. So we have Jacques and we have.
Almost the same.
So one is Jacques Malone and one is Jacques Antoine?
Yes.
Okay. Well, that's going to confuse me. All right. What are your thoughts? Does the defendant reside in your household?
Yes.
And does he reside in that household with his brother?
Yes.
Tell me what your thoughts are about my releasing him to return to the home. Are you in favor of that, or are you opposed to that? Are you against it?
In favor of that.
Okay. Can you tell me what, if I release your son to return to the home, do you feel that your son will be in danger?
No.
Or do you think that you'll be in danger?
No.
And why do you feel that you wouldn't be in, neither of you would be in any danger?
Because for 18 years and we've been together, it was only three of us always in the house and play together. But it's on bad jokes. No.
All right. All right. And Mr. Albrecht, how about you? Would you feel comfortable with my releasing your brother home?
Yes.
Okay. State any questions of either Mr. or Ms. Albrecht?
No, Your Honor.
All right. Mr. Albrecht, the defendant. Sir, I found probable cause for both of these charges. I'm going to set bond on the aggravated battery charge in the amount of $1,000, the domestic violence charge in the amount of $100. That's going to be a total of $1,100. I'm also going to require that you not commit any hostile contact with the victim in this case, which is your brother. All right? What that means is I have jurisdiction over you. I do not have jurisdiction over your brother. Should your brother feel as though you are being hostile or behaving in a hostile manner toward him, all that needs to happen is the police need to be called, and your conditions of release will be revoked, and you'll stay in jail until this case is resolved. You understand that?
Yes.
I'm also going to require that you not consume any alcohol, possess any weapons or firearms, and that you obey the rules of the household. State, is there anything else?
No, Your Honor.
Ms. Albrecht, anything else?
When he go be released, please.
I'm sorry, did not hear you.
When he go be released.
You've got to make arrangements to post bond. And as soon as bond is posted, he'll be released. That's not my area. So you can talk to the folks at the jail. All right?
Thank you.
I forgot to ask, Robin, does he qualify for pretrial release? That's what I thought. Okay, thank you for coming in. Good luck, Mr. Albrecht. Next, I have Bradley Bailey.
Each mental health, Your Honor.
And I will waive the appearance, Your Honor.
Okay.
We do have a victim approaching as well, Your Honor.
All right. Any arguments as to probable cause on any of these charges, Ms. George?
No, Your Honor.
Okay. All right. Good morning. Tell me your name, please.
Jessica Smith.
All right, Ms. Smith, you've been identified as the victim in this case, the defendant being Bradley Bailey. I have reviewed the charging affidavit and see that you reside together as a family. Is that right? All right. You've heard me now explain this twice, so I'm hoping that people will hear this and they'll go, I remember when the judge said this before. My job is to make a determination as to probable cause. I've made that determination on all three charges. What are your thoughts about Mr. Bailey returning to the home that you share?
Absolutely zero problem. He did not get physical with me. This was a verbal altercation between me and my child.
Okay.
He tried to restrain me. The arresting officer, I assume she was the arresting officer because he was not on premises when he was arrested. He had taken a walk with his two children.
Okay.
I assume who it was. She determined that he attacked me based on video from a security camera in my home on the patio. He was restraining me. She says he choked me. He did not.
Okay. All right. All right. State, do you have any questions for Ms. Smith?
No, Your Honor.
All right. All right, Mr. Bailey. Oh, we've waived Mr. Bailey's appearance. All right, and why have we waived his appearance?
Mental health.
Okay.
He's a combat veteran with PTSD.
I would prefer he be here so that he would hear from me what I've explained to other defendants. I have no doubt that I'm going to find probable cause and appoint the Office of the Public Defender. And so his public defender can explain to him how this works. Does he reside, Ms. Smith, does he reside? We've already covered this. I think I read something about his leaving. So he lives in the home with you?
In the home, him and his 2 children took a walk.
Okay.
We lost tempers. It was verbal. It got loud. Him and his 2 children left and walked the block. And I think what I heard from his mother this morning, or I'm sorry, last night, was that he was picked up at the clubhouse in our neighborhood.
Do you all have firearms in the house?
He used to have his mother's revolver. Okay. He was repairing it for her. He used to be an armor, so I don't remember if it's been repaired and returned.
All right, this is what I'm going to do. I'm going to find probable cause based upon the charging affidavit. I understand Ms. Smith has told me under different information. I am going to find probable cause on the most serious charge, which is the battery by strangulation. I'm going to set bond in the amount of $1,000. I'm going to set bond on the assault and on the kidnapping in the amount of $100 each.
I'm sorry, kidnapping?
That's the charge. There's been no objection to probable cause, so I'm going to find probable cause. But I'm setting a very low bond, a relatively low bond.
Yes.
So bond is going to be $1,200 total. All right. I'm going to order that Mr. Bailey not engage in any hostile contact. Ms. Smith, that makes you in charge. If you feel as though he's lost control and is behaving in any hostile way, I understand that. But you understand my role, and I understand your role. All right. Should you feel as though he's behaving in any hostile manner, you can call the law enforcement, and his conditions of release will be revoked. I'm going to order that he not consume any alcohol while on bond, that he not possess any firearms or weapons, and any weapons or firearms be turned over to the sheriff's office within 24 hours of his release. Anything else from the state?
No, Your Honor, I don't believe DCF was called.
Okay. All right, good luck. Thank you for coming in, Ms. Smith. Next, I have DeAndre Colwood.
Yes, Your Honor.
All right, so I have that Mr. Colwood is charged with contempt of court for violating a court order. It appears as though this is an injunction for protection from domestic violence. I find probable cause. State, did you want to be heard on conditions?
Yes, Your Honor. State has no objection to you setting a bond on the violation of the no contact order. However, this court could find PC and set no bond, so there's no objection to a bond at this time. However, would ask that you revoke his out on bond, the 21MM 6042, as it is the same victim listed in the no contact order that he's picked up today, or yesterday.
All right, I've been handed the out on bond non-monetary release form from the clerk.
It was pre-trial
It
diversion.
was on pretrial release? All right. I'm going to find probable cause, as I said a moment ago, on the violation of the no contact order. I'm going to set bond in the amount of $2,500. I'm going to revoke his pretrial release on 2021 MM 6042. Should he be released? Mr. Colwood, I know that it's redundant for me to tell you not to have any contact. You already have an injunction requiring you have no contact directly or indirectly with the victim in this case. Ms. Guichard, I don't know what else I can do other than keeping you in the jail with no bond at all, but a condition of your release on the new charge is to not violate the previously entered court order not to possess any weapons or firearms, not to consume any alcohol or non-prescribed drugs. And as I said earlier on the PTR will be revoked. You'll have to take that up with the judge that released you on that case.
Your Honor,
I'm appointing the Office of Public Defender to represent.
Your Honor, could I please have that case number? Because my sheets, I don't have any out on bonds on my sheets here.
Sure, that's 2021 MM 6042.
Thank you.
Thank you.
We still have no contact, still no contact.
Yes, still a no contact. All right, next I have Anthony Caprio. We have Ms. Torres approaching, I believe. All right, Ms. Torres, you were previously sworn. All right. And we have Mr. Caprio.
He's approaching, Your Honor.
All right, Mr. Caprio is charged with battery, domestic violence, tampering with a witness to hinder communication to law enforcement, and also false imprisonment. Does the defense have any argument on probable cause?
No, Your Honor, I'm having a really hard time accessing everything here.
All right, were you able to review the charging affidavit?
I can't even get it to work. Nothing's working, I'm sorry.
I know the feeling.
And just for the record, usually I make the argument based on history. I don't have history on my sheets as well, Your Honor, so,
He has no priors, Your Honor.
There's no history.
Okay.
Look, it says he qualifies for pretrial release, Your Honor. I would just ask for pretrial release in this case.
All right, so, Ms. Torres, you've now heard me say this 3 times, so I know you're paying close attention. You understand part of my job this morning is to determine whether a crime there's probable cause to determine a crime has been committed. I'm going to make a finding on these 3 charges that there is probable cause. The other job that I have is to determine conditions of release. So it's my job to ensure the safety of the community at large, and you in particular. What do you want me to know about permitting Mr. Caprio to return? It looks as though you reside together?
No.
You do not?
I do not.
Okay. I looked at a lot of you this morning. I apologize for getting them confused. You do have children together, is that right?
Yep.
Okay. What is your thought about my imposing conditions of release? What do you think?
I just want him to come home.
Okay.
I want him to come home. I don't mind him contacting me for the kids or none of that.
All right. Well, he came to your apartment. Is he welcome at your apartment?
To pick up the kids, yes.
Okay.
That's it, though.
All right, so long as he doesn't act in a hostile fashion, right?
Yes.
Okay. State any questions for Ms. Torres?
Yes, Your Honor, one. He does qualify for pretrial release, which is what I explained to you this morning. Do you have any objection to him being placed on that?
No, I feel safe, by the way. I don't think he's going to come back and do anything.
Okay. All right.
I think it just escalated a little bit. I don't think it's going to happen again.
All right. And that pretrial release, will that be weekly reporting?
Well, Georgia, Your Honor, so he's supposed to return it back to Georgia.
Yes.
So we're making telephone.
Telephone?
State, yes, Your Honor.
Okay. All right. All right, I'm going to find probable cause on all 3 of these charges. I am going to release Mr. Caprio to pretrial release. Mr. Caprio, it's going to be it'll be a little more complicated for you since you do not reside locally. Okay, it's going to be your responsibility to understand the conditions of pretrial release. Your failure to understand what you're supposed to do will not be any defense to you should you violate those conditions, because your pretrial release can be revoked and then you could be put back in jail until this case is resolved. Do you understand that?
Yes, Your Honor.
All right. A special condition of your pretrial release is no hostile contact with Ms. Torres. I have jurisdiction over her. I'm sorry, I have jurisdiction over you. I don't have jurisdiction over her. What that means is no hostile contact is in her perception, not your intent. So should she feel as though you're behaving in a hostile fashion, all she's got to do is call law enforcement and you'll, the pretrial release will be revoked. You understand?
Yes, Your Honor.
All right. No alcohol or unprescribed medication, no weapons or firearms, and you can have contact so long as the contact is not hostile. Yes, ma'am.
DCF was also contacted, so they would ask for a condition to comply with DCF if an investigation is.
Do I have the authority to require him to cooperate with DCF?
To comply, yes, Your Honor, with any investigation that they start, if they start one.
They should. I don't think they will.
Well, subject to someone telling me that I don't, I'll take your word for it, State. I'm not sure that I have that obligation. It's a different area, but I am going to include in the paperwork that he's to cooperate with the Department of Children and Families in their investigation, their dependency case, and I'm going to appoint the public defender to represent Mr. Caprio. All right, Mr. Torres, thank you for coming in. Mr. Caprio, good luck.
All right, thank you, Your Honor.
Next, I have Julian Casanova.
Oh, Your Honor.
All right, and I have approaching Mr. Casanova's wife. Whose name I cannot locate on this document.
Chris Mary Villar.
I'm sorry,
Chris Mary Villar.
Ms. Villar, all right. Is it Mary Villar, or that's your middle name is Mary?
No, it's Chris Mary is my first name. I don't have a middle name.
All right, so it's Villar?
Villar is the last name.
Villar, all right. All right, Ms. Villar, you've now paid attention while I've said this 5 times. You understand my job, so let me do my job and then I'll inquire of you. I have reviewed the charging affidavit. I see Nova resides in Ocala with his wife, Ms. Villar, who's present. I'm going to find probable cause on the charge of battery and aggravated battery on a pregnant person. Don't know why it's person. Does Mr. Casanova qualify for pre-trial release?
No, Your Honor, the charge.
Okay, that's what I thought. Okay. All right, so Ms. Villar, as I've indicated to other folks previously, and you've been here and you've heard me explain, my job is to first find probable cause. I've found that. It's then my job to determine conditions of release. What are your thoughts about my releasing Mr. Casanova to return to the home that you share?
I think that's fine.
Is that fine? Are you in fear of any danger from him? All right. You understand that should I release him on no hostile contact, Mr. Casanova directed at you, I have jurisdiction over you, but not of your wife. So should she feel as though you're acting in a hostile manner, all she's got to do is contact law enforcement, and your conditions of release will be revoked. Do you understand that? Okay. All right. Having found probable cause, I'm going to set bond on the aggravated battery on a pregnant person in the amount of $1,000, $100 for the domestic violence battery, so that's a total of $1,100. No hostile contact, no weapons or firearms, no alcohol or drugs. And Mr. Casanova, since you live in Ocala, it's a little bit distance away. That distance is going to create some problems. It's going to take extra effort on your part to make sure you follow all court appearances. You don't miss a court appearance. I find the farther away you get from the courthouse, the more difficulty folks have to find their way to the courthouse. Okay? Yes, sir. All right, sir. You want me to appoint the public defender's office to represent you?
If I decide to get a public defender, can I decide to get a private defender after?
Yes, I can appoint the public defender, and should you determine you want to hire private counsel, they can substitute in. Okay?
Okay, just that's fine.
All right, I'll appoint the public defender. Thank you for coming in, Ms. Villar. You have a question?
So no contact or?
No hostile contact.
Okay, so I can't have contact with
You
him.
can have contact, you can come home, but if he becomes hostile, it's up to you to contact law enforcement and make sure that they know that he's violating his conditions of release.
Okay, thank
All
you.
right? All right. Who are you here on?
Alex Lucy, FUSI, he's on the second docket for, I think, doing a rock dock this morning.
I don't know that I have the afternoon cases yet, do I? Have you worked something out with the state?
No, we haven't had a chance to speak, so whenever you get a break, I'll talk to her.
Okay, all right, that's what we'll do. I have no problem with resolving this afternoon's cases this morning. They just haven't given me the documents yet.
I was at the BRC.
I thought I saw you.
Yeah, and then I went to Horizon where they're doing this video, and then they told me that they were bringing over the FC people, so I've been running around this morning. But I'm glad to be here with the state and you.
Good.
And my client's there, so that's good.
All right, well, it's good to see you this morning.
Thank you.
Jump up and let me know if anything else I can do. I had a feeling I might not be able to address your case yet. All right, next we have Kevin Mirvalus.
Vice President, Your Honor. Your Honor, can you give us about 5 minutes when you call that attorney case so we can pull him from upstairs?
Absolutely. All right, and do we have Ms. Mack here? Okay. All right, I've reviewed the charging affidavit on Mr. Mirvalus. I am finding probable cause. I'm setting bond in the amount of $1,000 on the aggravated battery on a pregnant person, $100 on the criminal mischief. State, do you want to be heard on conditions of release as far as contact? According to the charging affidavit, Mr. Mirvalus and Ms. Mack reside together?
Yeah, sure. State would ask for all the normal conditions: no contact with the victim, separate residences, one-time return, no weapons.
All right. Without Ms. Mack here, I'm going to follow that recommendation. I'm going to require that Mr. Mirvalus have no contact directly or indirectly with Ms. Mack. That can be modified by another judge on another day. There'll be no contact. Mr. Mirvalus can return to the residence one time with law enforcement to collect personal effects. Mr. Mirvalus, you're going to have about 10 minutes. Law enforcement's not going to wait around while you start moving furniture. You can get your personal effects. You're going to have no contact directly or indirectly with the victim, Ms. Mack. That means no phone calls, text messages, Instagram, anything where you're contacting her, leaving flowers for her, talking to friends to talk to her on your behalf. No contact directly or indirectly. No alcohol, drugs, firearms, and I've addressed return. State anything else?
No, Your Honor.
All right, Ms. George, anything on behalf of Mr. Mirvalus?
No, Your Honor.
All right, I'll appoint the public defender to represent Mr. Mirvalus. Good luck, sir.
Your Honor, did you say separate residence as well?
Separate residence. Jasmine Pizarro. All right, and do we have Mr. Castro? Okay. All right, I've reviewed the charging affidavit from Ms. Pizarro. I'm going to find probable cause on the charges of battery and aggravated assault. I'm going to set bond in the amount of $500 on the battery, $100. Oh, I'm sorry, the aggravated assault with a weapon is the more serious charge.
My sheet says she qualifies for pretrial release.
She doesn't. She doesn't.
She does not. Okay.
Okay.
Robin from pretrial release says she does not, probably because of the aggravated assault.
Correct, Your Honor.
All right. So I'm gonna find probable cause. The aggravated assault with a deadly weapon is the more serious charge. I'm gonna set bond on that in the amount of $1,000. On the domestic violence battery, the amount of $500. Mr. Castro is not present. State, do you want to be heard on conditions of release?
Your Honor, State would just ask for all the standard conditions with a no contact with the victim.
All right, I'm going to require Ms. Pizarro have no contact directly or indirectly with Mr. Castro. That means no talking to friends to talk to him on your behalf, any text messaging or emailing, no leaving of flowers, no contact directly or indirectly. That can be modified later should a judge want to address that. There's going to be no alcohol or drugs, no weapons or firearms, maintain separate residence, and return one time with law enforcement to collect personal effects. I'll appoint the public defender to represent Ms. Pizarro. All right, good luck, Ms. Pizarro. All right, next I have Lavarius Stewart. All right, this is a lot of charges. There are 7 of them. I'm not sure that's the correct number of charges. Ms. George, have you had a chance to look at this charging affidavit as far as any probable cause?
I don't even, can I please have the case number? I don't even have a case number.
This is 2022 CF 6828 AO. The charges are robbery by sudden snatching, false imprisonment, battery, domestic battery by strangulation, petty theft, criminal mischief, battery, tampering with a witness to hinder communication to law enforcement. And I think our victim is Ms. Otley. Is Ms. Otley here? Ms. George, do you need a minute?
Yes, Your Honor, please.
Okay.
Excuse me, Your Honor.
Yes, sir.
Question for you. Are we going to go straight through to second session, or are we going to take a break so we can call the inmates and other facilities?
Do you all have a preference? I prefer to go through, but I'm going to defer to what works best for security.
We can go straight through. We just need a little time just to call them, so that's why I was asking.
All right, I think what we'll do is we'll get through this and we'll take maybe a 30-minute break.
10-4.
And then we can do the rest of the cases and get done early. Does that work for you?
Beautiful.
All right, good. I got it beautiful. Does that work for you, State?
Yes, Your Honor.
And Ms. George, I know you're doing 5 things right now, but does that work for you if we do the call the afternoon early?
Yes, Your Honor.
Okay, good. Well, then we're all in agreement, aren't we?
Your Honor, would you like me to point a PC for each of the charges?
I'm sorry?
Would you like me to point a PC for each of the charges?
Would that
situation?
I've read the charging affidavit. I think that they're. Ms. George, would that help if I hear from the state as far as the PC?
Yes, Your Honor. I'm struggling over here.
Okay, all right. Ms. Fleming, you'll help Ms. George out.
Of course, Judge. Regarding, so occurred on or about June 12, 2022. In regards to the robbery by sudden snatching, attempted to snatch the cell phone out of her hands. He eventually was able to snatch the cell phone out of her hands and threw it on the ground, causing the back screen of the phone to crack. There's the robbery, sudden snatching, and the criminal mischief.
Is the petty theft subsumed under the robbery?
I think it's a lesser included. And then he started choking her, which caused her unable to breathe for a few seconds. There's the battery by strangulation. The tampering, he came behind and tried to call the police from the hotel room since her cell phone was broken. He came behind her, bear hugged her into the hotel room on the ground. There's the hindering communication to law enforcement. She was trying to get out of the hotel room. She eventually was able to get out of the hotel room. She started running down the hallway. He helped her again, started choking her in the hallway. She was able to get into another person's room. To try to get out of the hotel room. That would be false imprisonment, dating violence, and the battery dating violence is also lesser included of the bat strength.
That's what I thought. Okay.
And Your Honor, I have no argument as to PC purposes, but I just would ask that you treat some of the remaining counts as subsidiaries, given that they are lesser included.
Okay, all right.
There is no objection to that, Your Honor.
All right. Okay, I'm gonna find, so I guess I can find probable cause for a lesser included. It's just up to me to determine what the condition of release would be.
Yes, Your Honor.
All right. All right, I'm gonna find probable cause on all 7 charges. I am going to set bond in the following. And then, Madam Clerk and Madam Pretrial Release Officer, I'm doing this in the order contained on the charging affidavit, so if you need to write on that, that's probably easiest for you to do, right? Okay. All right, on the robbery, sudden snatching, I'm going to set bond in the amount of $500. On the false imprisonment, dating violence, I'm going to set bond in the amount of $500. On the battery by strangulation, I'm going to set bond in the amount of $2,500. On the petty theft, criminal mischief, and dating battery, I'm going to release the defendant on his own recognizance on those 3 charges, based upon the fact that they appear to be lesser included of charges I've already found probable cause and set a reasonable bond. And on the tampering with a witness to hinder communication, I'm going to set bond in the amount of $500. So robbery, false imprisonment, and tampering with a witness, $500 each. Battery by strangulation, $2,500. ROR on the remaining 3. I'm going to require there to be no contact directly or indirectly with Ms. Otley, and that victim's name is
Janaya Otley.
a lot of words on this page. Thank you, Janaya Otley. I don't know, do they reside? This was a hotel room. If they reside together, they'll maintain separate residences. The defendant may return one time with law enforcement to collect possessions. No contact directly or indirectly with Ms. Otley. No alcohol, unprescribed medication, weapons, or firearms. And I'll appoint the public defender to represent Mr. Stewart. Good luck, sir. Jamie Barreto. Or perhaps Jaime Barreto. Excuse me, 1 second. All right, Mr. Barreto is charged with domestic violence battery, and do we have Stephanie Avila or Avila? All right, I find based upon the charging affidavit there is probable cause. I'm going to set bond.
Oh, she qualifies for pretrial release, Your Honor.
State is no objection.
Pretrial release?
Correct.
All right, I'm going to release Mr. Barreto to pretrial release. No contact directly or indirectly. Maintain separate residences. Return one time with law enforcement. No alcohol or drugs, weapons, or firearms. Appoint the public defender. Good luck, Mr. Barreto. Shakia Cooper. All right, come on up, sir. Is it Johnson Maxius or Maxius Johnson?
Johnson Maxius.
Johnson Maxius, all right. Mr. Maxius, you were here earlier and you've been sworn, is that right? All right, all right. I've reviewed the charging affidavit. I find probable cause for the charge of battery domestic violence. Mr. Maxius, you've been here now 6 times when I've explained to folks in your situation. My job is to find probable cause and then determine conditions of release. What is your request as far as my release? Would you like to have contact with Ms. Cooper or no contact or no hostile contact?
Yes, I would like to have contact. She's incapable of harming me.
Okay, all right. Well, I guess that's to be seen, but you understand that if I release Ms. Cooper, no hostile contact, I have jurisdiction over her, but not over you. So whether her contact with you is hostile or not hostile is in your perception, not in her perception. You understand that?
Yes.
Okay. And do you reside together at the Orange Center Boulevard?
Yes, Your Honor, we have kids.
Kids together? Okay, all right. All right, I'm going to find probable cause. Does Ms. Cooper qualify for PTR?
Your Honor, we weren't able to interview Ms. Cooper at the time, but she does qualify if we can just do straight PTR.
Okay, all right. I'll release Ms. Cooper on pretrial release. Ms. Cooper, really important.
It's fine.
Okay, all right. Thanks, though. Ms. Cooper, I'm releasing you on pretrial release. There are rules. So it's really very important that you understand those rules and you follow those rules, because if you accidentally violate the rules, your pretrial release is going to be revoked. If you commit a law violation, that's going to revoke your pretrial release, and you'll sit in jail until this case is over, okay? I'm going to permit you to have to return to the home you share with Mr. Maxius. No contact that's hostile. As I've just said, that's in his perception, not yours. If you feel things get heated, you're going to want to leave to avoid violating your conditions of release. No alcohol, drugs, firearms, or weapons. And I think that will take care of that. Good luck, Mr. Maxius. Ms. Cooper. Brian Harris. All right, and do we have Taisha Bailey? All right. All right, I've reviewed the charging affidavit. I find probable cause on the charge of domestic violence battery. State, did you want to be heard on any conditions of release since Ms. Bailey is not present?
Just briefly, they are from out of state, so stay with us, they take that into account when setting his bond. He also has a recent probation violation. So state's concerned about his ability to show back up to court and to comply with court orders. And the only conditions they would ask that you impose is, I believe there was an allegation of alcohol use within the affidavit, so they would ask for a no drugs or alcohol provision.
Okay. I'm not certain, I show the state of residence is Mississippi.
Yes, Your Honor.
All right. I'm not sure how I can enforce a no contact, but I can make it no hostile contact. Does the state want to be heard on the differentiation between no contact and no hostile contact?
My understanding, Your Honor, is that I believe with our admin order, if the victim's not here, we are supposed to set a no contact order period.
Okay. Whether that works or not is not for our consideration this morning.
Yes, Your Honor.
I understand. All right, I'm going to find probable cause. I am going to set bond in the amount of $1,000. I'm going to require that Mr. Harris have no contact directly or indirectly with Ms. Taisha Bailey. No alcohol, no drugs, no firearms, no weapons. Maintain separate residence. Return one time to the marital residence to retrieve personal effects. That'll be in effect unless it's changed by a subsequent judge to review this case. I'm going to appoint the Office of the Public Defender to represent Mr. Harris. Mr. Harris, since you're going to be leaving here and going back to Mississippi, I would imagine, I don't need to explore that with you with any greater detail. You may have heard me mention earlier, it's been my experience that the farther you get away from the Orange County Courthouse, geographically, you tend to put these things, one tends to put these things in your rear view and not return for court appearances and not do the things you're supposed to do. I'm just going to caution you to be certain you follow up and make sure that your contact information, your address, your phone number, your email is available to the public defender who I'm going to appoint. And that you take this seriously. If you once you cross state line, if you realize I'm out of Florida, I have to worry about it, bad things happen if you don't pay close attention, okay? All right.
Your Honor, we have it that they live in California. I guess the victim is a traveling nurse and
Okay. Is it California?
I believe it's California.
It's California?
Yes.
Well, I had everything but California. I've got Louisiana, I got Mississippi. All right. All right. All right, good luck, sir. Teresa Hayes. All right, Ms. Hayes is charged with battery domestic violence. According to the charging affidavit, the victim and the defendant have been married for 15 years. And I'm looking for the name of the victim, Jason Hayes. Is Mr. Hayes here? Okay. I'm going to find probable cause. I'm going to set bond the amount of $500.
Ron, he does qualify for straight pretrial release.
Pretrial release?
There is no objection.
No objection? All right. I'm going to release Ms. Hayes to pretrial release. Since Mr. Hayes is not here, any objection to no hostile contact, or would you prefer no contact, subject to being changed by a judge at a later time?
Your Honor, I say we prefer no contact at this time.
That makes sense. All right. So Ms. Hayes, I'm finding probable cause that a crime has been committed and that you're likely the person that committed the crime. I'm going to release you to pretrial release. I'm going to appoint the Office of the Public Defender to represent you. Pretrial release has conditions. You're going to want to make certain you understand those conditions so that you're not accidentally in violation of those conditions. Mostly it's going to require you check in with a pretrial release officer on a regular basis. They may even be able to explain that to you before you leave the jail. I'm getting a head nod from pretrial release, so that appears to be the way that's done.
Yes.
I'm going to require, for the time being, you have no contact directly or indirectly with your husband, Jason, with whom you've been married for 15 years. You're to maintain separate residence for the time being. Until further order of the court, no contact whatsoever directly or indirectly. You may return to the marital residence one time to collect personal effects. No alcohol, no drugs, no weapons, no firearms. I'm appointing the public defender to represent Ms. Hayes. Good luck, Ms. Hayes.
Thank you, Your Honor.
Right. Devontae Hill. We have Mary Etienne. All right, does Mr. Hill qualify for PTR?
Yes, he does, Your
All
Honor.
right, state.
Your Honor, the state would reject PTR, and if you aren't inclined to put him on PTR, the state would ask for bond with PTR. Just he had a recent arrest in 2020 of bad DV with the same victim.
Okay, all right. All right, I'm going to find probable cause based upon the charging affidavit. I'm going to set bond in the amount of $500. I am going to require there be no contact directly or indirectly with this victim, and that is Mary Etienne. Maintain separate residences, no contact directly or indirectly, return one time with law enforcement to collect possessions, and no alcohol, drugs, firearms, or weapons, and appoint the public defender. All right, Edward Keith. All right, and do we have, the victim on Mr. Keith?
We weren't able to contact the victim. We have phone number.
Okay.
And I was trying to qualify Mr. Keith for pretrial release. He has no priors. I just need to verify some residential information, Your Honor, if you could do that.
All right, so what I can do is, if I order a pretrial release or bond, I'll do that. All right, thank you, Ron. All right, I've reviewed the charging affidavit. I'm gonna find probable cause. The victim is not present. I'm gonna require no contact directly or indirectly. and I can't, there's a bunch of names in here. Can you tell me the victim's name, do you know?
It's Kaz Stepp.
Kaz Stepp.
Yes.
Oh, there it is, Kaz Gregory Stepp. All right, no contact directly or indirectly with Kaz Gregory Stepp. If they reside together, they're to maintain separate residences, return one time to collect possessions, personal effects, no contact directly or indirectly, no alcohol or drugs, weapons or firearms. I'll release Mr. Keith pretrial release, or if he should not qualify, I'll set bond in the amount of $500.
Okay, thank you, Judge.
Thank you. And I'll appoint the public defender. Wanda Malloy. All right, I've reviewed the charging affidavit. Do we have Jennifer Morales? All right. I've reviewed the charging affidavit. I find probable cause on the charge of battery domestic violence. Does Ms. Malloy qualify? PT?
No, Your Honor.
Okay. Set bond the amount of $500. Require no contact, victim contact directly or indirectly. Maintain separate residences should they reside together. Appears as though the victim is the defendant's niece, so that may not be the situation. If they do reside in the same home, one time with law enforcement to collect personal effects. No alcohol, drugs, firearms, or weapons, and I'll appoint the public defender's office to represent Ms. Malloy. Right, Ms. Malloy. Sophia Michelson or Mickelson. All right, is this Mr. Zillarulo?
Yes, sir.
How did I do?
Great.
Zillarulo? Okay.
Good on names.
All right, Ms. Mickelson, is it Mickelson or Michelson? Mickelson? All right. Michelson, all right. Ms. George, have you had a chance to look at the charging affidavit? I know you're struggling this morning with technology.
Yes, Your Honor, I am. You have just a second.
She's reading.
No, Your Honor. Based on my reading, it states that she allegedly pushed the victim.
Okay. All right. I'm going to find probable cause on Ms. Mickelson. Mr. Zillarulo, it appears as though your relationship with Ms. Mickelson is that you're dating?
Yes.
All right. Do you reside together?
On and off. She stays at one place, she stays at my place.
All right. I've got a Hollywood, Florida address for her. Is that where she lives?
Yes, sir.
You live there or do you live here?
I have my own home. You're in Fort Lauderdale.
Fort Lauderdale,
Yes,
okay.
sir.
All right. You have now heard me say 7 times.
Yes,
I know
sir.
you've been paying close attention. Are there any conditions of release that you are concerned about my imposing? If I release Ms. Mickelson with no hostile contact, is that acceptable to you? Are you afraid of Ms. Mickelson causing you any harm?
I'm not afraid of her causing me any harm. think she learned her lesson.
Okay, all right. So you have no problem with her having no hostile contact with you? Okay. All right, I'm gonna release Ms. Mickelson. Does she qualify for PTR?
She does.
I'm gonna release her on pretrial release. And I'm gonna require no hostile contact. Ms. Mickelson, those are two things. Pretrial release has rules. You need to be certain that you follow those rules and you understand those rules so you don't inadvertently violate a rule of pretrial release. It's going to be more complicated because you're going to be located out of the county. So they're probably going to have you call in or Zoom or email. I'm not sure what they do, but make sure that you don't leave with any questions unanswered. They're going to explain it all to you before you get released. I'm going to require you have I'm going to restrict you from having no hostile contact with your boyfriend. You can have contact with him, but I have jurisdiction over you, but not him. Should he feel as though you're being hostile toward him, all he's got to do is contact law enforcement and your conditions of release will be revoked. And you'll sit in jail till this case is over, you understand? Okay. I'm also going to require you consume no alcohol or unprescribed medication or drugs during the term of your release. No weapons or firearms. Did you want me to appoint the public defender's office or did you want to retain private counsel?
She stated public defender, Your Honor.
All right, I'll appoint the public defender. Keep in contact with your lawyer. They can answer any questions that you got. They may even save you some travel time. Mr. Zerlo, do you have any other questions for me?
No, sir.
All right, thank you for coming in, sir.
Thank you, sir.
Jonathan Nollings. All right, good morning, sir. Tell me your name, please.
Thomas Jonathan Nollings.
Okay, well, it appears as though that Mr. Nollings is here on a warrant signed by Judge Dubois on the charge of battery, domestic violence. Based upon that warrant, I'm going to find probable cause. I don't have a charging affidavit, so I'm going to guess that. So you're the identified victim in this case, is that right?
Yes, sir.
Okay. Found probable cause. The question becomes. Do you have any concern about my releasing? What is your relationship with Jonathan?
He's my father.
Okay. Do you reside in a home with him?
Yes, sir.
And who else do you live with in that home?
My sister, my cousin, and my mom.
Okay. And how old are you, sir?
I'm 24 years old.
24 years old. All right. If I release him, do you have a problem with him returning to the home that you all share?
No, sir.
Are you afraid of him in any way as far as I can order he have no contact with you directly or indirectly, or I can simply make it no hostile contact. So if you feel as though he's being hostile with you, you can contact law enforcement and his pretrial release will be revoked. You understand that? Conditions of release? All right, State, is there anything you want me to know? I am without a charging affidavit because of the warrant. Anything I need to know? Anything you want me to know?
Your Honor, State's concerned regarding the contact. I understand the victim's testifying that he would like contact with his father at this time. However, State would ask for a no contact at this time. The defendant does have a prior child abuse case with his son, the victim who's here today. So that case is rather old. I believe it's from 2003. However, I believe it just potentially shows an ongoing potential issue between Mr. Nollings and his son. So State would ask for no contact at this time, which could always be changed by another judge at a later time.
Okay. So 2003, at that point, the younger Mr. Nollings would have been about 5 years old.
8, I believe he was born in 95.
And Your Honor, if I may, I would ask for a no hostile contact order. That incident occurred, as stated, back in 2003. And if you listen to the victim's testimony here today, he does want contact. My client was disciplining his child for allegedly calling his teacher out of her name. So I just ask that you consider the fact that that occurred back in 2003, and the victim is testifying that he does want contact with his mom.
Was there any, maybe you have a charging affidavit, or I can ask Mr. Nolan since he's here. Was there any injury that required, did you have to go to the hospital, or did you need any first aid?
In the case now, Your Honor?
Yes.
No, Your Honor, I just believe.
Your Honor, I believe
they met in the hospital parking lot due to pain and labored breathing.
Ms. George?
Your Honor, all I read was that. Your Honor, all I read in the arrest affidavit on my end was that he was held up against the wall for not speaking in the morning, and then he let go. My client let go. There were no injuries that I saw reported in the affidavit. And additionally, they did speak after this incident, and they did work everything out together. They went out to eat. I would ask that, considering the victim has testified, he is not afraid of wants contact, that we give him contact.
The injuries in the affidavit were photographed as follows: bruising on the right side of his neck, open wounds to his hands and arms, open wounds and bruising on his ribs and chest, and road rash on his left arm and shoulder.
All right, give me just one moment. Madam Clerk has provided me with a copy of the charging affidavit. Thank you, Madam Clerk. All right, I've got some concern. I understand that Mr. Nollings, Thomas Nollings, it's Thomas Nollings. You're Thomas and he's Jonathan?
Yes, sir.
Okay. Thomas Nollings is here, and he is here and has advised the court that he is not in any fear of his father, and has no objection to him returning to the home where they all reside, and that I order no hostile contact. Based upon the testimony that I've heard from Mr. Thomas Nollings, that in the home is the defendant, the victim's mother, and I think a cousin. Is that what you? Cousin. I'm a little concerned about the safety of this victim given that housing situation. So what I'm going to do at this time is I'm going to find probable cause. Does Mr. Nollings qualify for pretrial release? I'm going to order that he be released on pretrial release. I am going to order at this time no contact directly or indirectly. They are to maintain separate residences, and they are not to have any contact, as I said. Mr. Jonathan Nollings can return to the home one time with law enforcement to collect personal effects. They may be able to sort all this out. They may even go in front of another judge to modify the conditions that I'm setting at this time. There'll be no alcohol or drugs, weapons or firearms. I'll appoint the public defender to represent Mr. Jonathan Nollings, and I'll release him pretrial release, as I said a moment ago. Mr. Nollings, You're going to want to pay very close attention to the pretrial release conditions. Make sure you understand them so you don't accidentally violate them. And I wish you good luck. I'll appoint the public defender. Thanks, sir. Magdalus O'Connor. All right. And do we have Ms. Dujan here or any witness or victim on Mr. O'Connor? Okay, I see none. All right. It appears as though Mr. O'Connor was out on bond on a charge of carrying a concealed firearm, for which he's out on bond for $2,500. He has a charge today of domestic violence battery. I've reviewed the charging affidavit. I'm going to find probable cause. I'm going to set bond on the domestic violence battery in the amount of $1,000. No victim has appeared today to testify. I'm going to order no contact, directly or indirectly. Return to the I guess they are mother and son. If they reside together in the Raleigh Street apartments, they're to maintain separate residences, and then the defendant will be permitted to return one time to collect personal effects. No direct or indirect contact, no alcohol, drugs, firearms, or weapons. I'm also going to revoke the condition of release on the carrying a concealed firearm. And Mr. O'Connor can bring that up with the judge to whom that case is assigned. That's 2022 CF 6269AO.
And Your Honor, if I may.
Yes, ma'am.
I would ask that if you aren't inclined to revoke, you consider revoking and doubling the bond. My client is obviously disputing some of these allegations. This has been an incident that has been ongoing where she continues to be jumped by these the alleged victims. She is actually in the process of trying to figure out how to get a restraining order. Is also afraid. I would just point to the fact that, and this is based off of my client, because my face, she doesn't have history, but the only history that she stated she has is that one out on bond charge. She's never been in trouble. And they keep allegedly jumping her. She is terrified. Okay, calm down. And if you look at, I believe they keep showing up at her address. I'm just asking if you consider her history and the fact that she doesn't have a violent history with this situation, and consider if you are inclined to revoke, that you revoke it double as opposed to holding her in no bond. And even in the affidavit, I believe she mentioned being hit, trying to get away, all of those things, Your Honor. So I just ask that you consider those factors.
All right, I'm concerned that the other charge on the felony, firearm charge, and that was from earlier this month. So, State, what's your position on my? I've filed probable cause and set bond on the domestic violence charge. What does the state have a position on my taking action on the revoking of the bond on the firearm charge?
Yeah, sure. State was going to ask that it be revoked just due to them being so close in time temporally, and then this being a violent offense and her having arguably concealed firearm earlier this month. State's just concerned of this possibly escalating at a later time, so state was going to ask that it be revoked.
Okay. All right, Ms. George, I'm gonna stay with my original. I heard your argument. I understand your argument. I am concerned about the previous charge. It appears as though your client just bonded out a week ago, so I'm going to revoke that. He can certainly, she can certainly take this up. She can take this up with the judge to whom she's front of on that felony. But I'm going to set bond in the amount of $1,000 on the new charge. No contact directly or indirectly, no alcohol or drugs, no firearms or weapons, and no, and I think that'll take care of it. And I'll appoint the public defender. All right, Christopher Rock. All right, let me just look at, where are they, Bather? Good morning. Tell me your name, please.
Miranda Phelps.
Miranda
Phelps.
Phelps. I'm sure your name is in here somewhere in all these words, but I can't find it. All right, Ms. Phelps. I've reviewed the charging affidavit. This is Christopher Rock. I find that there is probable cause on the domestic violence charge. You've heard me explain previously that my job is to determine conditions of release. Are you afraid of Mr. Rock? All right. Do you reside together?
Yes.
If I release him, no hostile contact. If he is hostile toward you, you feel as though you can contact law enforcement and make sure they know that he's violated his conditions of release? All right, state any thoughts?
Your Honor, we just ask for a reasonable bond in the normal conditions. Given the victim's testimony, he says no objection to a no hostile.
Okay.
He's not eligible for PTR.
We're going to find that out right now.
We didn't qualify Mr. Rock for pretrial release.
Does he have a residence?
Have a residence. His last conviction was a robbery back in 2019. Let me check my admin order real quick.
Do we think it's the residence problem? Or
It's a residential issue.
Okay.
We were able to verify any kind of community ties. I believe we did a message with the victim to verify the information, but she's here, so.
All right, Ms. Phelps, and I just found your name on the charging affidavit right at the top. Ms. Phelps, you said you reside with Mr. Rock?
Yeah.
Do you have a place to stay?
We have an appointment with the coalition
Okay, all right.
tomorrow.
Okay, all right.
So that's where we're going to be staying.
Okay. All right, what I'm going to do is I'm going to find probable cause. I'm going to set bond the amount of $500. I'm going to require that Mr. Rock not have any hostile contact with Miranda Phelps. As I've indicated previously, I have jurisdiction over Mr. Rock, not over Ms. Phelps. So Ms. Phelps, if you feel as though he's being violent with you, you need to let him know that you feel he's being hostile. And Mr. Rock, you need to stop being hostile or your conditions of release will be revoked. I'm going to appoint the public defender. I'm going to require there be no alcohol consumed, Mr. Rock. Appears though alcohol was involved in this. I don't have jurisdiction over Ms. Phelps, as I indicated. She wants to drink, she can drink. You can't drink. You're not to consume any alcohol. You're not to consume any drugs that you're not prescribed. You're not to have any weapons or firearms while this case is going on. And I'm going to appoint the Office of the Public Defender to represent you. All right, good luck. Robert Saines. All right, have you reviewed the charging affidavit? I'm going to find probable cause to the charge of resisting an officer without violence and domestic violence battery. Does Mr. Saines qualify for PTR? Okay. I'm going to set bond on the battery domestic violence in the amount of $500, the resisting $100. Since we do not have Siobhan DeAssure. present. I'm going to order no contact directly or indirectly. Return to the maintain separate residence. Return one time with law enforcement to collect personal effects. No alcohol, drugs, weapons, or firearms. I'll appoint the office of the public defender to represent Mr. Singh. All right, good luck, Mr. Saints. Lyman Shipley.
Yes, Your Honor.
I'm sorry, was that directed at me? I didn't hear it.
Yeah, I said good afternoon, Your Honor.
Oh, good afternoon. All right. So we have approaching. Why do they make this so hard for me to read? Mayra?
Sorry, my name's Meyer Wagner. Good morning.
All right, good morning. There it is. All right, Ms. Wagner, this is now the 8th time, probably, maybe 9th. I've explained my role here. I do find probable cause on the charge of battery. I do see this happen in a hotel, and I see that. Are you all both from Littleton?
No, sir. So we're out of town. We're from North Carolina.
Okay.
We're actually here on vacation. Today's actually his birthday.
Happy birthday, Mr. Shipley.
Thank you.
And it was a misunderstanding. Truly, I was the one that was drinking. I can tell you it was a big blur. I told the housekeeper, like I said something to her in Spanish, and she called the people at the resort, and they was like, we just need to go home. He needs to go. We live separately.
Okay.
That's all.
All right. So you don't reside together in North Carolina?
We do not. He does come stays. He has his own business in Littleton, North Carolina. I live in Clemens, North Carolina.
Okay.
So he does come and stay on Friday, Saturday, and Sundays. But we both have our own places.
Okay. And are you afraid if I order no hostile contact? Are you afraid of him having any contact with you?
I'm not afraid of him.
Robin, does Mr. Shipley qualify for pretrial release?
Your Honor, his last offense was April of 2022 for battery. It says an unborn child, out of state, and he does have some out-of-state convictions of second-degree kidnapping, assault on a female, the battery charge, of course, on an unborn child. He does have some arrests.
Okay, so that would be no. Okay. No, that explains why. Robin, I understand why you gave me all that information. I appreciate it. That's no for all those reasons. Okay. All right. What I'm going to do is I'm going to find probable cause. I'm going to set bond on this charge in the amount of $500. I'm going to order that Mr. Shipley not have no hostile contact with you. So what that means, Ms. Wagner, is should you find that he is hostile toward you, I have jurisdiction over Mr. Shipley, but not over you. Mr. Shipley, if your girlfriend, Ms. Wagner, expresses to you that she feels that you're being hostile to her, it's your job to remove yourself from that situation. Otherwise, she can call law enforcement, and your conditions of release can be revoked. So $500 bond, no hostile contact, no alcohol or drugs, weapons, or firearms. Mr. Shipley, I assume you're going to be returning to North Carolina.
Yes, Your Honor.
My experience has been the farther you get away from the courthouse, the less likely you are to be successful. Not you, but one. So I'm going to encourage you to pay attention to this. Once you cross the state line, don't forget about us. All right. I'm going to appoint the public defender's office to represent you. You can always retain counsel to substitute in, but you'll have somebody that you can contact if you've got any questions about what goes on going forward. Okay.
Yes, Your Honor.
All right. Good luck, Mr. Shipley, and happy birthday.
Thank you, Your Honor.
Thank you, Ms. Wagner. All right. Next, I have Willie Blount.
Yes, I know.
All right, this is an out-of-county warrant for driving for failure to appear, and the bond is $263. Do we know why it's $263?
Whole day docket for the day.
Okay.
Straight
I was
through.
curious more than anything. All right, based upon the out-of-county warrant, I'm gonna find probable cause. I'm gonna stay the bond at $263. So Mr. Blunt should be able to, well, if he's able to post that, he can go back up to Seminole County and take care of that charge.
All right, thank you.
All right, good luck, Mr. Blunt.
Yes, sir.
Next, I have Christian Lowe.
He refused, Your Honor.
I will waive his hearing.
All right, it looks as though he's here on an out-of-county warrant. Public Defender, Ms. George, is waiving his appearance. The warrant is for homicide, and that warrant is out of Broward County. I'm going to use the warrant as the probable cause, and I'm going to stay the bond at none. What was the reasoning?
He refused.
Thank you. All right. I have Chris Cheroux.
Yes, Your Honor.
Mr. Cheroux is charged with a violation of probation. He's also charged with possession of cannabis and resisting an officer without violence. Am I correct that the violation of probation was on view because he was on probation and then found with cannabis and? All right.
Yes, Your Honor.
All right. I'm gonna take this in the new law violation order, Division 17, 2022 CF 6811AO, possession of cannabis and resisting an officer without violence. I'm going to find probable cause on each. I'm going to set bond on the possession of cannabis in the amount of $500, a resisting an officer without violence in the amount of $100. And I'm going to take no action on the Division 15 charge, 19 CF 12476. Do we know what he's on probation for?
He is on probation, Your Honor, for carrying a concealed weapon.
Is he on probation in multiple counties?
Yes, Orange and Brevard and Pinellas.
And Brevard and Pinellas. He's on probation in 3 different counties.
Yeah, let me.
Oh my.
Let me go into.
Looks like drug offender probation. Does the state want me to
Your Honor, in regards to the on-view VOP, state would ask that you set it at no bond until a violation comes through from his probation officer in one of those 3 counties, since he is on probation.
Let me just check the website, DOC website, but I believe so. Yes. He's on probation for Orange County, Brevard County, Pinellas County, and Hillsborough.
All right, so I only have jurisdiction to revoke his bond on the Orange County case. Is that right?
Yes, Your Honor.
Kind of a no-brainer, but
If I may, based on my client statement, he's stating that his probation officer told him they were not going to violate him. So I would just ask that you stay the bond you already set. If they would like to violate him, then they can, Your Honor. But his understanding was that they were not going to violate him.
well, I'm not going to consider what he told you his probation officer told him. It is an on-view. He's on probation on multiple counties. It is a drug charge. This is a new drug charge, but I think it's going to be up to Orange County Corrections to decide what they want to do with his probation. So I'm not going to take any action on it. But State, I appreciate your argument, and I appreciate the defense argument as well.
No action on VOP?
Yeah. I'm going to take no action. Because it's an on-view. They haven't actually filed a violation. Is this treated as, do I have to, unlike being out on bond, do I actually have to ROR, do I have to take action, do I have to ROR him, or?
That's my understanding, Your Honor. I wrote ROR because otherwise I think he'll be sitting on it, no bond, if you don't take action.
They still may end up serving a warrant because it's 3 counties. So did you want to keep it at a no bond, Your Honor? Just keep it at no bond, or?
I just, he's got to meet with his probation officer and tell him about new law violations. No, not on the new law violation. I'm just going to ROR him on the VOP. On the VOP or ROR. And I may hear about it later, but. All right, good luck, sir. I'm out of documents. I've got a private counsel. I'm going to take a brief recess for the afternoons, but if you had a chance to talk about, I don't know, is he there? Can we bring up, what's your client?
Alexander Fusi, FOSI.
Can we bring up Mr. Fusey? I don't know anything about the case.
It might be better if we read the, just leave it like come back in half an hour.
Half an hour?
It's fine, either way, I think she read the probable cause affidavit, so I'll just speak to her.
Okay, all right. All right, we're just gonna, do you all need 30 minutes? Is that too long, too short? 30 minutes seems comfortable. So while we do this, Mr. Fusey, I'm sorry, have a seat. Have a seat, Mr. Fusey. We're gonna take a 30-minute comfort break.
Yes. We do have another victim here. I didn't know if we wanted to address that.
Is it an afternoon case? See, I don't have any.
It's on a domestic violence case.
Okay, so is it on?
I believe it should be this morning.
So was the victim late or?
I'm not sure, Your Honor.
Okay.
There's so much.
I got you. Let's do this. We're gonna take a 30-minute break. Let's find out what it is. Let's handle that case and the victim that's here. Give you a chance to figure out what's going on. And then how many do we have in the afternoon? Anybody know? That's not the answer I was hoping for.
Only 19 felonies. It's not bad. 19 felonies.
Do that. All right. All right.
You're on.
We're gonna. Yes, ma'am.
The only issue, we'll probably have to move the Spanish to the back because they'll be on lunch from 12 to 1 o'clock.
Okay.
We'll have a Spanish interpreter.
I think that'll work. I think, and then we'll be done by 1:30.
Okay.
I could do 19 felonies in an hour. I think. What are those? Is that the afternoons? You have the afternoons. You still need some time on Fusey? Oh, it's right on top. Look at you, Madam Clerk. Killing it today. Yeah, why don't you, this looks like a pretty serious charge. Why don't I give you the half an hour?
Yeah, I'm fine.
All right. All right, we're going to be in recess now until noon. All right? And we'll do the Spanish interpreter cases last. And I'll sign these?
No, you have to do those.
Yeah. Let's do these now. Okay. What are these?
Our 30 degrees.
I'll look for the emotions.
Oh. All right, so do I need to look through all these, or are these all over 33 days and I'm just signing them?
If you just announce the name, I'll tell you if it should be granted or denied if an information has been filed.
I like it. Okay, we're still on the record. First one I have is State of Florida versus Brittany Carmine, 2022 CF 5317AO.
Granted, notice and on filing.
Granted and signed. Marvin Cordaway, 2022 CF 5045AO.
Granted, notice and on filing.
Christopher Enialudin, 2022 CF 5266AO.
5266 granted, notice and on filing.
Joshua Highfill, 2022 CF 4709AO.
Granted, notice and on filing.
Tyrone Johnson, 2022 CF 5316AO.
Granted, and no information notice was filed.
Gabriel Mayerquin, 2022 CF 3817AO.
Granted, notice and on filing.
Traina Owens, 2022 CF 4949AO.
Denied and information was filed.
Williams Sanchez, 2022 CF 5265AO.
Granted, no information notice was filed.
Veronica Patterson, 2022 CF 5275AO.
Granted, notice and on filing.
Quantarius Roberts, 2022 CF 5396AO.
Granted, notice and on filing.
Awesome. All right, anything else before I take a brief recess until noon?
No, Your Honor.
No, thank you, Representative.
All right, thanks. Enjoy your brief lunch or snack. See you in a bit. You're back on the record. Joe, did you get a chance to talk to the state?
Yeah, I spoke with the assistant attorney on Mr. Fleury's case, a little back and forth, and she was willing to agree to a reduction. I would still ask the court to consider even further reduction on the bond. I have spoken with pretrial release. They said that you can't put him in pretrial release because of the charge. You can't order that he is supervised for drug testing through pretrial release, which I think is a very good condition based on the facts in this case. To consider. I also said that maybe, I know we're getting a little bit further into what might help his case, but maybe substance abuse education or something along those lines with the bond, but I'd be happy to be heard as far as the amount in.
All right, well, let's do it. I got ahead of myself. So put your name on the record.
Joseph Knapp.
All right, and we have Mr. Knapp is here on behalf of Alexander Fusey. Is Mr. Fusey there? I know we had him stand up an hour and a half ago. Mr. Fusey, come on up. Mr. Fusey is charged with trafficking in heroin greater than 4 grams and possession of drug paraphernalia. I've reviewed the charging affidavit. I do find probable cause on both charges. State, what's your position on a reduction of bond? The bond schedule calls for $100,000.
Yes, Your Honor. The bond schedule for the heroin does call for $100,000. Due to Mr. Fusey having limited criminal history, the state was okay with lowering it to $50,000, which would be half of what the bond schedule calls for, which the state thought was reasonable, given that Mr. Fusey is an Uber driver, and there seem to be drugs littered throughout the entire vehicle, which is state's main concern. It's a public safety concern that he was driving arguably impaired and had drugs littered throughout when that is his occupation. So state was willing to stipulate with defense to $50,000 on count 1. So state's asking for $50,000 on count 1 and a lesser included of or treating 2 as a subsidiary of 100. So there's no objection.
Okay. All right. And then, Mr. Knapp, what do you think your client, what would you like to argue on behalf of your client?
Your Honor, you've read the facts in this case. Obviously, he was cooperative during the stop. There was numerous amounts of paraphernalia relating to marijuana use. He is a medical marijuana card holder, but that's no excuse to have, lots of paraphernalia around the car. He does admit that he is a user of these controlled substances. What he's described to me is that this is not heroin like it looks like it goes into your arm. This is a substance called Molly, which is a recreational drug, and the street value on this is less than $300. He's not a dealer under any circumstances. He doesn't have the money to afford a $100,000 bond. He doesn't have the money to afford a $50,000 bond. So I explained to the state, I said, if, I appreciate the agreement for the reduction, but if we treat this as a possession of controlled substance type of situation, I think the appropriate bond would be between $5,000 and $10,000. That secures that he will be present for these proceedings. He's already retained counsel, and I think the special condition that he report through pretrial services for drug testing randomly will also ensure that he is.
Don't know what that meant, but I heard everything you said. If you're not done, disregard that voice.
That was all I had. He lives with his grandparents. His address hasn't changed. It's still the same address. He's not a flight risk. I'm not going to argue for like a bond hearing right now, but I would ask for a reduction. And it's within the court's discretion too.
Okay. All right. I have reviewed the charging affidavit. I don't find and I recognize the state's concern about the location of the drugs and the paraphernalia where they were found, but I don't find anything aggravating in this circumstance. So what I'm gonna do is I'm gonna set bond on the trafficking in heroin in the amount of $10,000. I'm gonna set bond in the amount of drug paraphernalia in the amount of $500. I'm gonna release Mr. Fusey on pretrial release will be for random drug testing. Is that right? Can we do that?
It'll be drug testing through PTR.
That's the way I wanted to say it.
Testing through PTR.
All right, thank you, Robin. Drug testing, random drug testing through pretrial release.
PTR, yes.
Mr. Fusey is not to possess or consume any non-described medication or drugs, no alcohol, and keep in contact with his counsel who's appeared on his behalf and been here all morning. All right? All right, Mr. Knapp, anything else?
That's all I have. Thank you.
All right, State, anything else?
There you are.
All right. All right, good luck.
Good to see you. Thank you.
Good to see you.
Thank you very much.
Supposed to be some attorney that's gonna appear virtually, remotely.
Okay, how am I supposed to do that? Oh, Mr. Herman, good morning. Good afternoon. I can see you. Can you see me?
Can, Your Honor. I just unmuted. How are you?
I'm great. I don't know. That must be the virtual meeting. Bear with me just 1 minute. Make sure I sign everything. That's for you. And Mr. Herman, who do you represent this afternoon?
I was retained an hour ago by the family of Howard J. Singh, Jaisingh.
We have any idea where I might find that? Somewhere in the. Bear with me, Mr. Herman. My clerk is gonna magically produce that document. Yes, sir.
He's on the felony docket, Your Honor.
Okay. Magic today.
From upstairs.
All right, so this is Howard J. Singh. Mr. J. Singh is charged with burglary with an assault or battery.
Yes, Your Honor. I think, Your Honor, not to interrupt, is the jail saying he's not present yet? He's in a different room?
Yeah, give us about 5 minutes to get him from upstairs, and we can bypass him about 5 minutes to get him down.
Okay.
Your
You
Honor,
want to have Mr. Go ahead.
What I may do is I'm a block away. I may come over to the courtroom because I'd like to review the probable cause affidavit. Is there a state attorney in your courtroom or no?
There is. Ms. Fleming is here.
Well, if
All right, so you want me to just let you go, and I'll set this aside, and I'll see you when you get here.
I'll be there in 10. Thanks, Judge.
All right, Mr. Herman, the state says he can get
He can get it from the clerk.
Okay, all right, and we're in courtroom 7C.
See you in 10. Thanks, Judge.
Okay, bye, Mr. Herman. See you later. Oh, that'll make that easier. Okay. Okay, so are we ready on Mr. Guzman? Is that the next one we take?
Paulo Nunez. Oh, this is Spanish. Oh, wait a minute.
Okay, so what did I mix up?
Oh, the arraignment.
All right, did I just combine two things I shouldn't combine? Maybe we start with Mr. Rivera, Mr. Guzman. I'm gonna have you help me. I may have mixed up your order. So there's Mr. Guzman.
Yeah, this is.
Is that right?
Yeah. So just take a hit, but.
Nice. Okay. Yeah.
Okay.
All right. So first one we have is Mr. Guzman.
You surety bond, Your Honor.
Didn't I hear you? He bonded out?
Yes, sir. Surety bond.
Okay. Makes my job easy. Okay. Next one I appear to have is Neil Paul Morrison.
He's medical, Your Honor.
I will waive the appearance, Your Honor, and enter a plea of not guilty.
Okay. All right. Mr. Morrison appears to be charged with DUI. And you're entering a plea of not guilty. Public defender is appointed.
The pretrial will be Division 83, June 27th at 8:30 in courtroom 6C.
Next I have DeBoris Ankrum.
He refused, Your Honor.
Okay. All right, he's charged with stalking, and we're going to roll that to tomorrow. It's a Division 50 case.
No, Your Honor, I will waive and enter a plea of not guilty.
All right, enter plea of not guilty. Set that for. All right, so these are arraignments. All right, so what's that going to be set for?
Division 50, pretrial will be July 22nd at 9 o'clock in courtroom 4E.
All right, next I have Jean Antoine.
He's medical, Your Honor.
He is represented by Regional Conflict Counsel, Your Honor.
Okay. All right, so we're going to reset that for another in-jail arraignment or enter plea of not. So he's represented by counsel as
By RCC, Your Honor.
by RCC. So have they filed a notice of appearance and written plea of not guilty? Are we going to set it for PTC? Or are we going to? Is this Mr. Antoine?
No, sir. This is Mr. Dixon, next client.
Gotcha. All right, so I'm either. So what are we going to do with the RCC case? Well, he's got counsel.
I don't see a waiver or anything else, Your Honor.
And he's not there?
He's medical.
No, Your Honor.
No. Let's do this. I can either roll this tomorrow and have him appear. Let's do that. All right. Mr. Dixon. Mr. Dixon's here for in-jail arraignment on the charge of violation of a domestic violence injunction.
Your Honor, I will enter a plea of not guilty.
All right. All right, Mr. Dixon's case is going to be set for.
Division 50, July 22nd at 9 o'clock in courtroom 4E.
All right. Next, I have Terrence Foy.
He's medical, Your Honor.
All right. He's represented by the Office of the Public Defender, Miss George.
I will waive and enter a plea of not guilty.
All right.
Division 61, July 15th at 1:30 in courtroom 7C.
All right. Next, I have Tidarius Preston.
Say that name again, John.
Sure. Preston is the last name. Preston.
He's medical, Your Honor.
Okay.
And I will waive and enter a plea of not guilty.
All right. Enter plea of not guilty. Division 62.
It'll be August 8th at 8:30 in courtroom 12C.
Next, I have Charles Wilberson. Mr. Wilberson is charged with trespass, and he has 33 days in.
There was no. Can I have just a moment on Mr. Wilkerson?
I'm sorry, I did not hear you, Miss George.
Can I have just a moment?
Sure. While you look at that, let me inquire of the state. I don't have a charging affidavit. I just have that he's got 33 days in on trespass.
Your Honor, seeking to convey an offer because it is a true victim case. And I don't believe an offer has been conveyed to a victim or them given the right to show up.
Okay.
So there has been an offer, but would you like an affidavit anyway?
If there's been an offer, I'm just wondering whether Mr. Wilberson wants to resolve the case today.
There wasn't an offer conveyed because it's a true victim.
I understand.
And Your Honor, we will enter a plea of not guilty.
Okay. Enter plea of not guilty, and it's Division 83 case.
It's going to be June 27th at 8:30 in courtroom 6C.
Does Mr. Wilberson have? Is he here on other things, or does he have a bond on this?
Yes, Your Honor. Yes, he has a bond of $250 for the trespass, for the criminal mischief, $500.
Okay. All right. Ainsley Williams. All right, Mr. Williams is charged with resisting an officer without violence. Ms. George?
No offer. I will enter a plea of not guilty, Your Honor. There is not an offer made by the state.
All right. That's the Division 84 case?
It's gonna be July 7th at 8:45 in courtroom 4B.
All righty. Are those all the in jail arrangements?
Yes.
Okay, great. All right, the next case I've got is Suprente Collins.
Good morning, Judge.
All right, good afternoon, Mr. Collins. Mr. Collins is charged with trespass after warning at the Lynx bus terminal.
Yes, Your Honor, the offer from the state is an adjudication of guilt, credit time served, and no return to 455 North Garland Avenue. And Mr. Collins would like to accept and enter plea of no contest.
How many days does Mr. Collins have in?
Today's two, Your Honor.
Okay. All right, so Mr. Collins, have those folks all been sworn? Do we want to swear them? Somebody there that could swear them?
And Your Honor, he does have a probation violation.
Oh, he does?
Warrant out of Illinois, but they will not extradite, and he has an active warrant out of Indiana.
Okay.
No extradition.
All right, so this probably not asking, not requiring you to give us a legal opinion, but probably won't result in his being arrested on a violation of probation out of state.
All right, I mean, they're not going to extradite.
Gotcha. All right. All right, Mr. Collins, you promise to tell the truth, the whole truth, and nothing but the truth, so help you?
Yeah.
Okay. All right, sir, tell me your name, please.
Suprente Collins.
Mr. Collins, you're charged with trespass on property after being warned to not do that. That is a misdemeanor. You understand you have the right to be presumed innocent of that charge, and it's the state's burden to prove your guilt, right?
Yeah, I understand.
Okay. Your lawyer tells me you want to resolve this case by entering a plea of no contest, which means you're not admitting guilt. You're not going to contest the charge with the understanding that you'll be sentenced to the time you've already served. Is that what you want to do?
Yes, sir. I just have one question. How do I go about taking away the pass from the bus station? Because I don't even know why I'm there. I don't even know I'm trespassing.
Okay. According to the charging affidavit, you were at the Lynx bus terminal, and a witness named Joel Solano said that you've been trespassed from there in the past. And a few months ago, you were provided a copy of the trespass issued on December 23rd of last year, which was good for a year, and they wanted to prosecute you. That's what you're being trespassed for, being where you were previously told you were not welcome.
Okay.
Does that help?
Okay, no problem.
All right. Has anyone pressured you or forced you against your will to enter this plea?
No.
Are you under the influence of alcohol or drugs that may have impaired your ability to think clearly?
Yes, sir.
And you understand that if you're not a U.S. citizen, you can be deported by entering this plea?
Yes, sir. I totally understand.
All right. I've been advised that you are currently in a probation violation status for 2 other states, that they're not going to come get you for that probation violation, but this could have conceivably some impact on whatever probation you're on in those other states, Indiana and Carolina?
I'm not worried about it.
Right. All right. If you're not worried about it, I'm not worried about it, okay? All right, sir, I'm going to accept your plea. I'm going to adjudicate you to be guilty of trespass. I'm going to sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've already served in jail, which means you're going to be released today as to this charge and this charge alone. If there's something else you're in jail for that we don't know about, you got to resolve those cases before you get out, but I'm not aware of anything. I've not been told. I'm also going to propose court costs, which are $323.
273.
279?
273.
273. and a public defender fee in the amount of $50. And I'm going to give you up to a year to pay that off. All right, sir, you have 30 days within which to appeal the sentence that I've just imposed. If you want to appeal, your appeal has to be in writing, and if you cannot afford an attorney for that appeal, I can appoint one. All right, sir, good luck.
Okay, thank you.
Mr. Herman, were you ready on Mr. J. Singh, or did you need a minute?
Here it is. I wanted to read it. I haven't read it yet.
Take all the time you need. Just wave your arms or make a loud noise. No worries. Okay, good. Next I have Trevon Harris.
Ron, you have a booking number? Should wait, Trevon Harris, let me see.
You need a booking number?
Yes, but I may be able to. 13557? Is that?
Is this from the misdemeanor waivers?
You got an inmate number, 220-13557?
Bonded, Your Honor. Bonded.
You bonded?
Yes.
Nice. Antonio Jackson.
It's mental health, Your Honor.
And I will waive him. Sorry.
Okay, you're gonna waive his appearance?
Yes, Your Honor.
All right, it looks like Mr. Jackson is a co-defendant with Brittany Thomas, charged with petty theft. I've reviewed the charging affidavit. There's probable cause. I'm gonna set bond in the amount, stay the bond in the amount of $500 and appoint the Office of the Public Defender to represent Mr. Jackson. Also, conditions are not to return to the Walmart located at 2500 South Kirkland Road in Orange County, Florida. McDarrell Keith.
It's mental health, Your Honor.
Okay.
Your Honor, I will waive the appearance. I just ask that you take no action on his bond cases. He has been deemed incompetent to proceed in those cases, Your Honor.
Okay, so I have 1, 2, 3, 4, 5, 6, 7 active cases. He's incompetent to proceed on all of those? Is that your understanding?
That's my understanding, Your Honor, but I can go back and check each individual one. He has had a long history of incompetency with us, Your Honor. And I'm just gonna double check each one.
I don't believe he's been adjudicated incompetent in all of them, Your Honor. However, I believe that's where they're all heading.
Okay.
I checked the 21MM255, and it is currently in proceedings. However, I just checked the 22165, since that's the newest other than this one, and I don't see a NOI on it yet. However, I'm assuming it's probably coming.
All right. Do we know what was at 1171 East Plant Street? It just says business.
One second.
And most specifically, I'm just wondering whether, if there's no aggravating circumstances, I'll stay the bond at 500.
It's a 7-Eleven, Your Honor.
Charging affidavit is just several sentences. All right, is there anything, State, that you want me to do with this other than finding PC and setting bond?
No, Your Honor.
As the other cases? All right. All right, Ms. George, anything else I can do that you need?
No, Your Honor.
All right, I'll find PC and take no action on the outstanding cases and set bond in the amount of $500. Mr. Herman, you look ready. Mr. Herman, I don't mean to rush you. You can take as long as you need. I got all afternoon to be here. I'm not trying to rush you. I'm trying to get you on your way. But don't let me. If you want a few minutes with Ms. Fleming, you're more than welcome to do that.
I am ready to go.
All right. Do we have Mr. J. Singh there? Mr. J. Singh, come on up. All right, I have before me this afternoon Howard J. Singh is charged with burglary of a dwelling with an assault therein.
Has Your Honor had the opportunity to review it?
I have.
Okay. Good afternoon, Mr. J. Singh. This is Attorney Scott Herman. I represent you. I was retained by your family approximately 2 hours ago, but I have not been out to the jail to introduce myself to you yet. But I have filed as your attorney, so I will be representing you. Please don't say anything, okay? Can you hear me, Mr. J. Singh? Okay, he's nodding yes in the affirmative. Your Honor, I understand he was booked for a F1 PBL. I understand that is no bond at this time. I was going to be asking for a bond. If Your Honor reviews the cause affidavit, the allegation is that one punch between Mr. J. Singh and a male who he has known for the past 5 years, but they're not in any sort of domestic relationship. This is, I guess, a love triangle is the allegation, and that he took one step into the alleged victim's residence in order to deliver a punch to his cheek. I do know, Your Honor, Mr. J. Singh has no prior criminal history, no prior affairs to appear. He is gainfully employed as an audio and video technician. He was a graduate of Full Sail University, which he moved here for 6 years ago. He has a stable residence. He has a 2-year-old child who he supports. I was going to be asking for bond in the amount of $5,000, which would assure his future appearances at all court proceedings, but I understand it is an F1 PBL. I'm well aware of the statute of burglary battery, but Your Honor, I would argue to the court that Mr. J. Singh is not a flight risk, does have ties to the community, is gainfully employed, does have family. The only matter that could be of issue, Your Honor, just full candor to the court, is I believe he and this victim live in the same apartment building, my client being a resident of the 5th floor, the alleged victim being a resident of the 7th floor. So if the court needs to order no return, or obviously there will be a no contact order, but he can potentially abide by any conditions the court sees as appropriate. But we're asking for a monetary bond in the amount of $5,000 on this case, but I'll defer to the state.
All right, State?
Yes, Your Honor, given that it is a PBL, state is asking that we held no bond at this time. This is for it to be set as an Arthur hearing at a later time so the victim can be heard since they are not present here today. As defense counsel put on record, it is of issue that they do live in the same building. And in this particular case, it did seem like the defendant kind of sought out the victim, him getting off the elevator, victim, I believe, getting on. Defendant turned around and followed him back up. So state will be asking for no bond at this time, so the victim can't be heard at that Arthur hearing, given that it is a PBL. So state would just ask that we state at no bond for an Arthur hearing within the next 5 days.
The victim was not available to appear today?
No, Your Honor.
So the victim would have a right to be heard as it relates to arguably any stage of the proceeding. I'm going to be setting conditions of release. He is presumed to be innocent. I'm finding probable cause. The only thing that I'm going to do today is determine conditions of release, monetary and non-monetary. I'm just wondering if the victim was present today. I can order no contact, which he would. The most severe thing I'm thinking out loud that he could do would be to request the court order him not to have any contact. We're going to address that in a moment because it is problematic. But conditions of release other than that, such as monetary bond, is within the sole discretion of the court. I'm not accepting a sentence. What I'm doing is I'm thinking through the prejudice to not having the victim present today, recognizing that he has a constitutional right to be here for all. Has the state had any contact with the victim? Was he not available today? He couldn't be reached. Do you know? Couldn't be reached. Mr. Herman, if I release your client and require no contact, direct or indirect, does he have someplace to go other than 20 West Lucerne Circle?
Yeah, Your Honor, I spoke to his wife about that, and she indicated if there was a no return to the scene ordered, he potentially has a friend he could stay with while the case is open and pending, because I anticipated that being an issue. And according to his wife, yes, there's a place he can stay.
All right, this is what I'm going to do. He is not entitled to a bond because of the nature of the charge. I have read the charging affidavit, and I've heard argument of counsel on behalf of Mr. J. Singh. I'm going to set bond over the state's objection. That bond is going to be $15,000. I'm going to require that Mr. J. Singh have no contact, directly or indirectly, with the victim in this case, Mr. Jared Torres. It's been explained to me that Mr. Torres and Mr. J. Singh reside in the same apartment building. Mr. J. Singh, I need you to hear me. And your lawyer is very good. He'll explain to this. He'll answer all your questions. But you're to have no contact directly or indirectly. That means no texting, no emailing, no sending friends over there to talk to him. If he contacts you, you can't contact him back because I have jurisdiction over you. I don't have jurisdiction over him. I'm ordering that you that you maintain separate, not only residences, because you don't reside together, but you are not to return to the scene of this offense, which is 20 West Lucerne Circle. If you need to have somebody go get your personal effects out of the apartment, you can stay somewhere else. You're not to return to that property. You're not to consume any alcohol or drugs, possess any weapons or firearms. You're not to have any contact, I think I've already said, with Mr. Torres. If you are at the Publix and you run into Mr. Torres and you see him in the aisle next door, it's your responsibility to retreat and leave that premises immediately. Do you understand that, sir? Okay. All right. No contact means no contact, and it's entirely upon your responsibility not to have contact with him rather than the other way around. If he walks up to you and wants to talk to you about it, you're to turn around and walk away. All right? Okay. All right. State, anything else that you have a concern about that you want to put on the record?
Nothing else.
All right. Mr. Herman?
No, Your Honor, just briefly, because I don't have the benefit of being J. Singh. Mr. J. Singh, I'm going to contact your mother and sister and let them know that your bond has been set in the amount of $15,000. I will put them in touch with a bondsman, so I'll make sure I handle all that side of it. But as the court said, you must maintain separate address, so I will talk to your family about finding a place for you to live while this case is open and pending, okay? He's nodding in the affirmative.
He's nodding his head. All right, good luck, Mr. J. Singh. Thank you, Mr. Herman.
Thank you, Your Honor. Thank you for your time.
All right, good to see you. All right, I have James Letizia. All right, Mr. Letizia is charged with battery. Do we have anybody here that identifies themselves as a victim in that case?
Want to take a look here? Yeah, just take this one on.
Ms. Fleming, do you know if you've got anybody here on Letizia?
No.
Okay.
I checked the hallways, Your Honor, there's nobody out there.
Okay, all right, good, thanks. All right, I'm going to find probable cause on the offense of battery. Does Mr. Letizia qualify for PTR?
Ronnie, we didn't qualify Mr. Letizia. He was in SafeBook at the time. And right now we show him as a unstably housed, no contacts.
Okay. All right. I'm going to set bond in the amount of $1,000. I'm going to require that Mr. Letizia have no contact directly or indirectly with a co-defendant named Blake Doble. He's not to have any contact with any of the victims or witnesses at the 7-Eleven, including Vishwa Patel. Or Prit Patel. Those two names are found in the charging affidavit. No alcohol, no return to that scene, which is 6777, 6 and 3 7, 6777 Westwood Boulevard at the 7-Eleven. No return to that location, no contact with co-defendant or or victims, no alcohol or drugs, no weapons or firearms. Appoint the public defender. Thank you, sir. Walter Posada. All right, Mr. Posada is charged with trespass after warning. Mr. Posada, do you live in Massapequa, New York?
Not anymore.
I'm sorry, I didn't hear you.
Not anymore. I live in Texas.
Okay, all right. All right, so you have a local address now?
Yeah, my address, the new address on the paperwork.
Okay.
Your Honor, the state also did convey an offer to Mr. Posada of an adjudication of guilt, credit time served, no return, and he currently has 2 days credit.
Okay, Ms. George, were you able to talk to Mr. Posada whether he's interested in resolving his case today? He's not obligated to do that.
That's just a moment here. Yes, Your Honor, we just ask that you set a monetary bond. We are going to fight this charge.
Okay. All right, I'm going to set bond, having probable cause, I'm going to set bond in the amount of $500. Appoint the Office of the Public Defender. As a condition of release, Mr. Posada is not to return to 8738 International Drive, which is an Avanti. He's not to have any contact with Ryan Archer, who's the hotel security manager. He's not to consume alcohol or drugs. He's not to possess any weapons or firearms. And if I've not mentioned it already, Mr. Posada, did you want me to appoint the public defender, or do you want to retain counsel?
He said he's going to hire, Your Honor. However, I would just ask for that one-time return with law enforcement so he can gather any things that he left at the hotel.
Okay.
Oh,
Yeah, my girlfriend was there.
okay. I take it back. He said his girlfriend grabbed everything, so he doesn't need that.
Okay, all right, good deal. Thank you. Good luck, Mr. Posada. Andrea Sharber.
She refused, Your Honor.
Okay.
Your Honor, could we try to reset for tomorrow? There is an offer to resolve the case.
All right, we can set Sharber for tomorrow, and Judge Bigney can see her. I have Brittany Thomas. All right, Ms. Thomas is charged with petty theft. She has a co-defendant, Antonio Jackson, and she's currently out on bond. Maybe someone can help me. It says, this looks like it goes back to 2020.
Yes, Your Honor, she bonded, and then the state's offer was PTD. She's been in PTD since 2021. She's currently in PTD, which will likely be revoked.
Gotcha. That's why it says PTD pending. I'm sorry. If I read the paperwork they give me. All right, so I don't need to take any action on that. All right, I'm gonna find probable cause.
She's on felony probation as well, Your Honor.
Oh, she is. Is there going to be a VOP on it?
Nothing yet.
Nothing yet? Okay.
Also the grand theft, another grand
Yes,
theft?
correct.
All right. She's on probation and pretrial diversion at the same time?
I don't know how, I'm assuming she got on pretrial diversion before she picked up the Seminole case.
Gotcha. I'm a little concerned that Ms. Thomas had a 1-year-old child in her lap. Among all the other things I'm concerned about. All right. So apparently this is a petty theft. I'm going to find probable cause. I'm going to set bond in the amount of $1,500. I'm going to appoint the public defender's office to represent Ms. Thomas. should she be released, she's not to return to the Walmart located at 2500 South Kirkman Road. She's to have no contact with the co-defendant, who is Antonio Jackson. No alcohol or unprescribed drugs or medication, no weapons or firearms. And I've appointed the public defender. All right, good luck. Next, I have Jason Tolan. All right, I have Mr. Tolan is charged with disorderly conduct at the airport. Mr. Tolan, do you live in Peekskill, New York still?
Yes, sir.
Okay. All right, I'm going to find probable cause on the charge of disorderly conduct. I'll be surprised if that charge stays that way. I'm going to stay the bond at $1,000. I'm going to require that Mr. Tolan have no contact directly or indirectly with the passenger with whom he is accused of being disorderly with. I don't know if we have that person's name.
I just wanted to ask, the state wasn't making an offer on this case?
State didn't make an offer this time due to it likely being charged as a battery at a later time if charged.
Okay.
If we have additional information regarding who the passenger is.
All right. So there's no point in me ordering that he not have contact with the other person because we don't know who that person is.
Effectively, Your Honor.
All right. I also, I'm not going to order that Mr. Tolan not return to the airport because I don't know how he's going to get home.
And Your Honor, if you would, if he would be accessible to bench offer, Your Honor, the state could always file the battery at a later time. It could only be going to the disorderly conduct. We don't even have the victim's information. He would like to accept a plea, if Your Honor would be agreeable to that.
Okay. I'm not going to do that. I appreciate Mr. Tolan wanting to get this resolved, but I'm not going to accept a plea at this time. There's no information charge. We're not sure what the charge will be. I'm going to set bond in the amount of $1,000, require Mr. Tolan have no contact directly or indirectly with any of the players here, any of the security officers at the airport, with the exception that he'll be permitted to fly out to go back to Peekskill. I am going to appoint the Office of the Public Defender to represent him. Mr. Tolan, my experience has been the farther away you get from us, the more likely you are to forget about us and not take this seriously and run into more trouble. So I'm just going to caution you that you're going to want to make sure you follow up with your public defender. If you want to retain private counsel on another day, you can do that and they can substitute in. I'm also going to require that while you're on release that you not consume any alcohol or drugs or possess any weapons or firearms. All right, sir, good luck.
Thank you.
All right, I have Tawana Washington. Looks like Ms. Washington is charged with criminal mischief and battery. And she currently has an active ICTP case.
Yes.
All right. I do find probable cause. Is there an offer? Is Ms. Washington interested in taking it? Do I want to set bond and set it for a PTC in front of the judge? I'm sorry, arraignment in front of the judge to whom it's assigned?
There isn't an offer this time, Your Honor, just due to the charge.
Okay.
The state would just ask for reasonable bond and conditions.
All right, I'll stay the bond at $250 for the criminal mischief and $500 on the battery. I'll appoint the Office of Public Defender to represent Ms. Washington and require that she have no contact directly or indirectly with.
I just got out jail April 19th. I have no. April 19th. All I did was go.
Stop.
It's talking about your album bond, you have the trespass that's open. It's in our. Right here.
Okay, I think Ms. Washington's talking to her lawyer. Because I can't hear. I don't. I'm going to require that Ms. Washington not return to 1491 South Rio Grande Avenue, which is the Bald Head grocery store. And I'm also going to require she not have any contact directly or indirectly with the with Mathana Ulami, the manager of that store. No alcohol or drugs, no weapons or firearms. And I'll appoint the public defender's office. Good luck.
You're taking up
Any action on our bond case?
I will.
All right.
Because it's currently, I think she's currently, is she been termed being incompetent on those other charges, or are they just pending? Is she in?
They filed an NOI. I don't believe it's actually, she's been adjudicated incompetent. No.
I'll take no action on those. On that. All right, next we have Carrie Pierre.
His behavior, Your Honor.
Okay.
Your Honor, can we reset for tomorrow? He also has an offer to resolve his case.
Okay, I think Judge Bigney would be more than pleased to visit with Mr. Pierre tomorrow. It'll be set for tomorrow. Next, I have Ezekiel Rivera.
He's not.
Mr. Rivera is charged with disorderly conduct.
The offer from the state, Your Honor, was a withhold of adjudication, credit time served, and court costs. Mr. Rivera would like to accept and enter a plea of no contest.
All right, how many days does he have in? 2
days, Your Honor.
All right. All right, Mr. Rivera, raise your right hand to be sworn, please.
It's 1 day, Your Honor.
I'm sorry, 1 day?
Yes.
Mr. Rivera, do you promise to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, Mr. Rivera, you've been charged with disorderly conduct, which is a misdemeanor. Your lawyer tells me you want to resolve this case today by entering a plea of no contest, which doesn't admit guilt. It just says that you don't want to contest the charge against you. Is that what you want to do? All right, you understand that you don't have to do that, and it's the state's burden to prove your guilt. By entering this plea of no contest, you're relieving the state of their obligation to do that. You understand that, right?
Yes, Your Honor.
All right. Has anyone pressured you or forced you against your will to enter this plea?
Your Honor.
Are you under the influence of alcohol or drugs this afternoon that may have impaired your ability to think clearly?
No, Your Honor.
All right. And you understand that if you're not a U.S. citizen, you can be deported by entering this plea?
Yes, sir.
All right, sir, I'm going to accept your plea of no contest to the charge of disorderly conduct. I'm going to withhold formal adjudication of guilt, so it's not going to appear on your record as a conviction. I'm going to sentence you to the 1 day in jail you've already served and credit you that day. So as to this charge and this charge alone, you're going to be released. If you've got any other charges holding you that we didn't know about or discuss, you got to resolve those before you get out. There's court costs of $273. There's $50 for the services of your lawyer. We'll give you up to 1 year to pay that $323. Mr. Rivera, you have 30 days within which to appeal the sentence that I just imposed. If you think my sentence is illegal, you can appeal me, but it must be in writing, and you must file it within 30 days. And if you need a lawyer to help you with that appeal, I can appoint one if you can't afford one, all right? All right, sir, good luck. Deanna Thomas?
She's medical, Your Honor.
And I will waive the appearance, Your Honor.
All right, so you're going to waive her appearance for purposes of setting conditions of release? All right, it looks as though Ms. Thomas is charged with disorderly conduct, which is sort of an unusual charge given the facts. I do find that I guess this would constitute disorderly conduct, although it's not routinely charged that way. I'm going to find probable cause and set bond the amount of $250 or stay at that amount. And I'm going to appoint the public defender's office to represent her.
What was the reason? I don't know. What was the reason?
Medical?
Medical, yes.
All right, Dusty Wheaton. All right, good afternoon, Ms. Wheaton. Ms. Wheaton's charged with soliciting without a permit. Should read just like the last one. Charge is different. Is there a plea offer on this?
Yes, Your Honor.
Wait, Ms. George.
The offer from the state is a withhold of adjudication, credit time served, and court costs, Your Honor. And Ms. Wheaton would like to accept and enter a plea of no contest.
1 or 2 days?
2 days, Your Honor.
2 days, thank you.
She has an active warrant out of North Carolina, but they are only limited extradition.
Okay, will this affect, is it a VOP?
No, it's a burglary, just a regular warrant, a VIP.
All right. All right, so Ms. Wheaton, your lawyer tells me you want to resolve this case today by entering a plea of no contest. Is that what you want to do?
Yes.
You understand that you're not obligated to do that, and it's not your burden to prove your innocence. It's the state's burden to prove your guilt. By entering this plea of no contest, you're relieving the state of their burden to prove your guilt. You understand that?
Yes.
Has anyone pressured you or forced you against your will to enter this plea?
No.
Are you under the influence of alcohol or drugs this afternoon that may have impaired your ability to think clearly?
No.
And you understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes.
All right, Ms. Wheaton, I'm going to accept your plea of no contest to the violation of a county ordinance, which is a misdemeanor called soliciting without a permit. I'm going to withhold formal conviction of guilt so it will not appear on your record as a conviction. I'm going to sentence you to the 2 days in jail that you've already served. So that means if there's nothing else holding you, you're going to be released today as to this charge. If there's something we didn't know about, or you didn't tell us, or they didn't find, and it's a hold, I can't do anything about that, all right? They're also, all right, there's court costs of $273. There's $50 for the services of your lawyer. I have accepted your plea and I've imposed a sentence. If you think that sentence is illegal, it exceeds my ability to sentence you that way, you can appeal me. That appeal has to be in writing and filed within 30 days. And if you can't afford an attorney, I can appoint one. All right?
Thank you. You have a beautiful day.
Okay, you too. Good luck, man. All right, next I have James Nicholas.
O'Donnell?
I'm sorry, I have Nicholas O'Donnell. I looked at it wrong. Mr. O'Donnell, I apologize. All right. Mr. O'Donnell is currently charged with driving under the influence of alcohol or drugs to the extent his normal faculties were impaired. He also is charged with a misdemeanor of refusing to submit to a DUI test and also operating a motor vehicle without a valid driver's license. It appears as though Mr. O'Donnell is out on bond on a similar charge of DUI from April. So within 60 days, he picked up a new charge. He's also on that case charged with refusal to submit to a blood alcohol test. I've reviewed the charging affidavit. I find probable cause. I'm going to set bond in the driving under the influence case in the amount of $5,000. The refusal to submit to a DUI test, $500, and the no valid DL, $500. If you bond out, you consume no alcohol or drugs. Do not drive without a valid driver's license. Do not possess any weapons or firearms. And I'm revoking his bond on 2022 CT 676AW and 2022 CT 6. That can't be right. I think it's 676 and 677. Sorry, my bad. So the bond, those two bonds in the amount of $100 and $500 will be revoked. And Mr. O'Donnell, are you going to hire Mr. Oshevsky on the new DUI and refusal and no valid DL, or did you want me to appoint the PD?
He's gonna hire him as well, Your Honor.
Okay. All right. Good luck. Next, I have Jason Williams. You get that right? 5,500 and 500.
Good afternoon, Your Honor.
All right, Mr. Williams is charged with reckless driving and driving under the influence of alcohol or drugs to the extent his normal faculties were impaired. I find probable cause on both of those charges. I'm going to set bond on the DUI in the amount
We did qualify Mr. Williams for straight pretrial release.
Mr. Williams qualifies for PTR?
Yes, Your Honor.
It is no objection, Your Honor.
All right. All right, I'm gonna find PC. I'm gonna release Mr. Williams to pretrial release. Mr. Williams, really important that when they go over the conditions of pretrial release, that you understand them and follow them. Because if you don't do what they tell you to do, you'll violate your pretrial release and you'll end up back in jail until the cases are over, okay?
Yes, sir.
Did you want me to appoint the Office of the Public Defender to represent you?
Your Honor, he is going to hire private.
I'm sorry, I didn't hear you. Okay?
I'm sorry, I need to acquire private counsel, sir. I didn't have time. I'm sorry.
Okay. Is the public defender's office already appointed and then they substitute out, or I'm just not going to appoint them?
No, I would just ask that you not appoint us, Your Honor.
Okay. All right. Good luck. Good luck, Mr. Williams.
Rhonda, do you have case numbers, please?
Yeah, both of them?
No.
On both of them, the case numbers, I've got 2022 CT 3223 and 3224. Let me ask you this: they're going. Oh, there they are. You're going to the same division, right?
Correct.
Okay. Good deal. All right. Good luck, Mr. Williams. What's unusual? You did get that. Everyone was 5,500. You know what's unusual? We do a lot beforehand. You got there was 5,000.
They were all 500 at first.
Right. All right. I'm not calling into question your ability. All right. Far from that.
Your Honor, what is the condition also? Does he have a condition for that?
No alcohol, no drugs, no driving without a valid license.
Thank you.
Thank you, Ron. All right, so this must be, is it Aaron Kennedy?
He bonded.
Bonded. Blake Doble.
Yes.
All right, so this is the co-defendant of James Letizia. Boy, it'd be really helpful if I remember what I did with Mr. Letizia.
And Your Honor,
Yes, Ms. George.
I did have a PC challenge as to the robbery.
Okay.
My only argument as to the robbery, I would argue no PC as the items were already taken without force. My client was outside when the hair fell out of the backpack and they picked it up and took it back into the store. But at no point did the rest of the state that any items were taken by force or threat of force. Additionally, for the remaining charges, Your Honor, if you look at the affidavit, it does state that my client suffers from some mental health issues, so I would ask that he also be free from mental health pretrial release. He does appear to have some mental health issues, even with supervision.
He may not qualify due to the charge per the admin order.
I know regular pretrial release, but when it comes to mental health pretrial release.
Yeah, mental health.
It's
That's
different.
regarding mental health. Yeah, I believe he may not qualify due to the charge.
The charge?
Yes.
Is it the robbery that would be holding him up, or all the charges, or?
It's the robbery, and he did have a mental health detainment, but they released it.
I mean, I haven't.
So he was already screened.
Okay.
Yeah.
I didn't know.
All right, so Ms. George, your objection to PC is as to the robbery?
Only as to the robbery, Your Honor, yes.
All right, Ms.
They
London?
charged him with petty theft, Your Honor.
Your Honor, I believe counsel's argument was mostly that it was not by force. However, state would argue differently. And the statute reads it can be force, violence, assault, or putting in fear. So state would argue that it, and at least put the victim in fear. The victim was able to retrieve it. However, the victim did say he was battered, and even though he retrieved the merchandise, it was still taken out of the store and with the intent to permanently or temporarily deprive the store owner of it. State would argue that there is PC for it. However, if your honor does not find PC, state would ask for 24 hours, as the affidavit is kind of confusing. As I believe there are 2 co-defendants and then the 2 store owners.
It is a little confusing, and then they refer them as defendant 1 and defendant 2.
Yes.
Can either the clerk or the state or PTR help me out? The Mr. Letizia's case was handled several defendants ago.
You want to know what the bond?
Yeah, what did I do on the other one?
You gave him it was a misdemeanor plea, so he received a $1,000 bond on the battery. He was given a no contact with co-defendant, no contact with victims or witnesses, no alcohol or drugs, do not return to the scene of offense, and no weapons, firearms, or ammunition. That was on Letizia, James Letizia.
Okay, so was the $1,000 on the battery?
Yes.
And then what about the other charges?
That was all he received was a battery. He just came in on the battery. That was for James Letizia.
Oh, that's all he was charged with? Okay. Oh, okay. I had a different recollection. I'm glad you pointed that out to me. Thank you. All right, this is what I'm going to do. On the robbery, I'm going to set bond in the amount of $1,500. I'm going to find probable cause on the robbery. On the resisting merchandise recovery, I'm setting the bond in an amount of $100. Petty theft, $100. Battery, $500. And resisting a merchant, $100. So that's going to be $2,300 by my rough math. 15, 100, 100, 500, 100. So we've determined that I cannot place Mr. Doble on mental health PTR, correct?
It's the charge that's going to disqualify.
I understand. I'm going to require that Mr. Doble have no contact directly or indirectly with James Letizia. He's not to return to the 7-Eleven located at 6777 Westwood Boulevard. He's to have no contact directly or indirectly with either Ms. Patel or Mr. Patel. No alcohol or drugs, no weapons or firearms. And I'm appointing the Public Defender's Office to represent him.
Your Honor, this affidavit is confusing. I'm trying to find his father. It appears this is his father that was the co-defendant. I don't have the name, but due to the mental health issues, if you read the affidavit, the father was stating not to touch the son, that he was going to pay for it due to his mental health issues. And then that's when the incident occurred. He is the one that kind of takes care of him. So I ask that in this particular circumstance, you at least allow him to have contact with his father.
All right, so Mr. Letizia is Mr. Doble's father?
It says, told him not to touch his son. I guess it's hard because yes, he is, Your Honor. That's his father. And his father tells the officer that suffers from tells the store representative that he suffers from mental health issues and that he'll pay for the items. I just don't want him to get out and be stuck with no one to help care for him, Your Honor, due to the mental health issues.
All right, I have Mr. Doble as being transient. Does he stay with Mr. Letizia?
Your Honor, in mine, okay.
Hang on a second, Ms. George. Robbins for pretrial release is going to
Yeah,
solve all
we
these
ha-
problems for us.
he wasn't, Mr. Doble was unable to get interviewed. I believe he's in safe book at the time. Let me see. Oh, no, that was Letizia. Give me one moment because we have a David Doble for a father, for his father's name. And I know when you look under James Letizia, we don't have an alias for David Doble. Let me just double check. Yeah, we have no aliases for James Letizia, but we did get a chance to interview Mr. Blake. And for the father, we have a David Doble.
All right, so I think there's a question as to whether Mr. Letizia is Mr. Doble's father, or if a David Doble is Mr. Doble's father. I can understand your concern about Mr. Doble needing to be cared for. I've already ordered Mr. Letizia have no contact with Mr. Doble. That didn't come up.
It's because in the affidavit, it's a lot going on, Your Honor. It said, "Don't touch my son." And so at that point, I thought that Defendant 2 was his father. But it may not be. Because it just says Defendant 1, Defendant 2 said not to touch his son. I just didn't want him to be in a position where he was not able to have contact with his dad. But it appears that that may not be his father. So
He was mentioned, you know,
So I am okay with the original condition.
Okay. All right, if something changes, the conditions release can be, you can seek to modify those if that becomes an issue.
Thank you.
All right, thank you. All right, anything else on Mr. Doble before we move on to Mr. Doe?
No.
Okay. All right, I have John Doe. All right, so this fellow is charged with possession of a counterfeit driver's license and providing false ID. I've got a concern about setting conditions of release on somebody that I don't know their identity.
I don't have that information yet.
So do we know anything further about Mr. Doe's identity?
Ron, I just sent an email. I did receive an email yet that they do not have. He was printed, but we do not have a name, which is I can resend an email, but that was the last I received. Let's see. Let's see. May take.
Yeah, I've got a real concern about setting conditions of release because there's no way to determine who this gentleman is.
I just sent an email out. Let's see if I can pull up his history and see if anything's in there.
I've got an address for him.
Yeah, I mean he was screened. I don't.
Your Honor, I think the issue may be he is from out of the country. He's from Jamaica, Your Honor.
Okay. Last time I checked, people that live in Jamaica have names that are not.
No, correct, Your Honor. I was just given pretrial. Maybe that would help because he said he's from Jamaica to find out his identity.
Yeah. I was just trying to pull up his rap sheet, but I still don't have a name.
Shall we pass him for a moment?
Yeah, Your Honor, because I sent an email to my supervisor.
I want to, obviously these are charges for which this individual is entitled to release. But I don't know once we release him if we can find him again.
Okay, I just received an email. As of now, we do not have a name. We're waiting for the officer to bring him down to be rapid ID'd. So I guess they may have to reprint him again or get some extra prints to get a name.
We just move it to end of session, Your Honor, to try to give this process some time.
I heard the second part, but I didn't hear the first part.
Can we move them to the end of session so we can try to give this process some time to figure this out?
Let's do that. All right, we're going to revisit Mr. Doe. Next, I have Anthony Gandy.
Anthony Gandy is mental health, Your Honor.
All right, let's revisit Mr. Gandy tomorrow. Judge, I'm going to be a big fan of Judge Bigneys. Next, I have Henry Gibson. I'm sorry, Miss George.
If I'm not mistaken, Your Honor, I don't believe there was actually an offer to resolve this case. So I would just ask that you set a bond, because he can't resolve it tomorrow, Your Honor.
All right. So we don't have Mr. Gandy present?
No, Your Honor.
Mental health.
Have you had a chance to review the charging affidavit?
Yes, Your Honor.
All right. Are there any challenges for probable cause?
I did not, Your Honor.
Okay. All right. I'm going to find PC without objection on destruction of evidence. I'll set bond in the amount of $1,000. Resisting an officer without violence, I'll set bond at $100. And appoint the Office of the Public Defender to represent Mr. Gandy. Henry Gibson. All right, Mr. Gibson is here on a warrant for his arrest, signed by, I'm going to guess that's Judge Chu. I'm guessing.
I believe it was Judge Calderon.
Judge Calderon. Yeah, that makes more sense, doesn't it? That's an LC, isn't it? By Judge Calderon. Based upon the warrants, I'm going to find probable cause on the charges contained in the warrant, that being armed robbery, aggravated assault with a deadly weapon, aggravated battery with a deadly weapon, and aggravated stalking. I'm going to stay the bonds in the amount in the warrant, in the amount of $25,000, $5,000, $10,000, and $1,000. Should Mr. Gibson be released, he is to have no contact with the victim, no return to the scene, no weapons, firearms, or ammunition. I'll appoint the public defender to represent Mr. Gibson. All right, next I have Kayan Harper. All right, Mr. Harper is here on a warrant for his arrest for, looks like he failed to appear for a violation of probation hearing in February. His release was revoked. This is on 2017 CF 3231 AO. I'm going to find probable cause based upon the warrant and stay the bond at none on both charges. Public defender has not previously been appointed. I'll appoint the public defender to represent him on that charge. Next, I have Michelle Joseph. Ms. Joseph is charged with carrying a concealed firearm while she is out on bond on the charge of carrying a concealed weapon. I find probable cause on the new charge. Yes, ma'am.
It is a male, Your Honor. I think you said she.
Oh, I'm sorry.
No problem.
Michelle, okay. I apologize, Mr. Joseph. All right, I'm going to find probable cause on the charge of carrying a concealed firearm. I'm going to stay the bond at $2,500. I'm going to appoint the public defender's office to represent Mr. Joseph on this new charge. And I'm going to revoke his bond on the previous charge of 2022 CF 3797 AO. So he'll see the judge in Division 16 if he wants to address that. Next, I have Brandon Lauro.
And I'm going to remove.
All right, Mr. Lauro is charged with grand theft, third degree, more than $750 and less than $5,000. I've reviewed the charging affidavit. I do find probable cause for that offense. I'm going to set bond in the amount of $1,000.
Ronald, we did qualify Mr. Lowell for straight PTR.
Straight PTR? How old is Mr. Lauro?
20.
I think pretrial release might be better than a monetary bond. All right, Mr. Lauro, I'm going to release you on pretrial release.
Your Honor, the state would object or ask for bond with PTR.
Okay.
I understand the officer only charged the grand theft third degree, however, there seems to be several other charges in it, including potentially a battery. Brandon grabbed her by the neck and pushed her on the floor, right where she was gasping for air. It seems to be not just a theft offense, but also potentially a violent offense.
Okay.
Understanding that the officer only filed the grand theft.
You know, I did see that, and I was wondering why it was only as to the MacBook. That was returned at the scene, correct?
Yes, I'm not really sure, Your Honor. However, if you are inclined to put him on PTR, given that it was also a violent offense, it would ask for bond and PTR, or otherwise just straight bond.
Okay. All right. All right, Ms. George, anything? Mr. Lauro?
I would just ask for straight pretrial release, Your Honor. He is going to be monitored by pretrial release services, which is better than having him post just a monetary bond, Your Honor. And I believe that pretrial services monitoring him will be sufficient to ensure his presence, one, at court, and two, to protect from any further incidents.
On pretrial release, how frequently do they check in with folks? Weekly?
Well, he'll have an office visit, Your Honor. What did he, let me see what he scored, his risk assessment. We based it on the risk assessment, but.
Because it's my intent, I'm placing him on pretrial release to have better control over him.
He's a low, so we could do an office visit for this reason. Now he'll go for his first appointment, and then it will be up to the officer when they set the future appointments. But usually with a low, we do a telephone reporting. So if you wanted just to go on and do a bond with that, I mean.
All right. All right. I am troubled by what I see in the charging affidavit. I was going on just the charge that was filed. Mr. Lauro is 20 years old. This is what I'm going to do. I'm going to release him on pretrial release with a bond of $1,000. I'm going to require that he have no contact, directly or indirectly, with Alicia Therian and Ariana Therian.
You're on those victims? Victims, okay.
Victim, a witness.
Okay.
No return to 134. Does Mr. Lauro live at 134 East Muriel?
No, Your Honor, and if I may, he does not have any money to post a monetary bond, so he'd be held here. And I believe if you put him on pretrial release and require that he does the check-in, that he's willing to check in with pretrial personally without the phone call. If we could do that as opposed to a monetary bond, even if you order him to check in twice a month, however you would like him to check in, Your Honor, he's willing to do that.
Well, I was inclined to have him report weekly in person. Is that something PTR can do? If I order it?
I order in person.
Yeah.
Office visits weekly in person, you can do that.
See, that's my concern, Ms. Fleming. I know we flipped and flopped on this. I'm not that concerned about him coming up with $100. I am concerned about us having good control over him.
Understood, Your Honor.
So I'm going to change my change in what I just ordered. So bear with me.
Okay.
Let's start again. All right, Mr. Lauro, I'm going to find probable cause as to the charge that's charged, which is the grand theft third degree. I'm going to release you on pretrial release. The special conditions of pretrial release is that you're going to meet in person with your pretrial release officer on a weekly basis. That's actually more difficult for you to comply with than just putting money up, or even putting money up and calling in, okay? You're going to want to be very careful that you don't miss an appointment, or that you don't fail to follow the instructions of your pretrial release officer. They don't just blow it off, because your pretrial release officer can revoke your pretrial release. You'll be returned to jail, and you'll sit in jail till the case is over, okay? I am going to require, as I said earlier, that you're not to have any contact with the victim or the witness. You're not to return to the address of 134 East Muriel Street. You're not to drink, consume any alcohol or drugs, possess any weapons or firearms. And I'll appoint the public defender's office to represent you. Thanks for your help, folks. Good luck. That was a lot of words in a very short period of time.
We're also getting into the docket. Words get much harder.
They do, right? All right. All right, John Logan. All right, Mr. Logan's charged with grand theft. This is on a warrant, an arrest warrant. That it was signed by a judge. And I'm going to stay the bond. I'm going to find probable cause based upon the warrant. I'm going to stay the bond at $5,000 on the third degree grand theft, and also require no contact with victim, no return to the scene. I'll appoint the public defender's office to represent Mr. Logan. Chantini Miller. All right, Chantini Miller has two cases, 2022 CF 6819. That charge is possession of meth. I've reviewed the charging affidavit. I find probable cause. I'm going to stay the bond at $1,000. I'm going to appoint the Office of the Public Defender to represent Mr. Miller. And require that, Ms. Miller, and require that she have no contact directly or indirectly with Quincy Smith, a co-defendant. All right, then there are two out-of-county warrants for possession of cocaine in violation of PTR. Those are out of Volusia County, and those are no bonds. I'm going to stay the bonds at none.
They're 1,000 each, Your Honor.
They are 1,000
Yes,
each.
it's 1,000 each.
That's not what this says.
Let me check the warrant again.
Is it one or the two cases?
It's two cases. Let me see.
Yeah, it looks like there's a highlighted thing that says $1,000 bond, but on the
It's 1,000.
face sheet, I intend to do what Volusia County's directing me to do. So if there's a bond, that will be the bond.
What is that? I'm sorry, Your Honor, I'm just trying to find.
No, take your time. I'm seeing what you're seeing. Someone highlighted this for my benefit. It says 1,000, but then the face sheet says none.
Let me see what let me see the warrant. Why is it? I don't even know.
We will extradite.
Okay, this is odd. I'm only seeing for the fugitive warrant. I'm trying to find the warrant, the actual out-of-county warrants. Let me see what this says, the teller.
Because I just have a teletype and a face sheet and they're inconsistent.
This says Volusia.
Do you have something?
1,000 each, Your Honor.
1,000 each?
Yes, sir.
Then that's what they'll be set at.
Yes, 1,000.
What? There you go. All right, good luck. All right, I have Demetrius Odom.
He refused, Your Honor.
And I, Warner, I will waive the appearance. He does qualify for pretrial release. I would ask for pretrial release.
On that, please. I just want to check my admin order real quick.
On Odom? Or the last one?
Yeah, on Oldham.
Sure.
Yes, it's Philly. Here's his last one, back to
Shall we pass this case?
Yes, it's
All right, let's pass Mr. Odom for a few moments. We got two that we've passed. All right, next I have Eric O'Toole.
Surety bond.
On dead. Next I have Karen Paulino. All right, Ms. Paulino is charged with accessory after the fact, public order crimes.
Let's see. She has no priors. Just trying to check.
Do you happen to have the case number? I don't have a case number.
On Karen Paulino?
Yes.
2022 CF 6832. The charging affidavit is very difficult to follow.
Trying to.
Your Honor, if I may, I believe a felony was committed by arguably Vince, or allegedly.
That's correct.
Vince. And Karen was the operator of a vehicle. He got in the vehicle after she witnessed said felony and drove away.
Okay.
I believe that would be our accessory, as she helped him defer detection or arrest.
All right, Ms. George, any challenge to that PC? Okay, here it is near the bottom.
Oh.
Knowingly and intentionally assisting Vince Craig Rogers getting away from the scene and avoiding detention. Observed in committing the crime of aggravated assault with a firearm. Okay. All right, I'm going to find, based upon the charging affidavit, Ms. George, unless there's something else you want me to know, I'm going to find PC and stay the bond at $1,000.
Your Honor, she has no prior history. She was interviewed. She has no prior history. And I just checked her address. It is matching with her driving record. Can you just verify, Your Honor, that she is, I'm not going to give her a physical address, but she is located at Charlotte Court in Orlando?
That's what I've got.
Yes.
She has no priors. We could qualify for pretrial release.
All right, state any objection to my placing Ms. Paulino on PTR?
No, Your Honor, with the condition of no contact with her co-defendant or the victim of the underlying.
That sounds like a good plan. All right. So, Ms. Paulino, I'm going to release you on pretrial release. No contact with Mr. Rogers or any of the other witnesses or victims in this case. You're also not to return to 4631 Lamont Drive. No alcohol or drugs, no weapons or firearms. I'm going to appoint the public defender's office to represent you.
Your Honor, you have a case number, please?
Sure, it's 2022 CF 6837.
Thank you, Judge.
You're welcome. Ms. Paulino, be certain that when they explain all the conditions of pretrial release, you understand them. You don't want to be in violation. It will revoke your PTR and you'll be sitting in jail until the case is resolved, okay?
And no contact with the co-defendant?
No contact with the co-defendant or the victim or return. All right, thank you. I have Nikita Roberts. All right, Ms. Roberts is charged with possession of drug paraphernalia, possession of meth, and she's out on bond for being in possession of Utilone. And she's got a pretrial conference on the 5th. There's a warrant on the possession of drug paraphernalia and meth, signed by Judge Dubois. I'm going to stay the bonds. I'm going to find PC based upon the warrant. I'm going to stay the bonds in the amount contained in the warrant, which is $150 for the possession of paraphernalia and $2,000 for the possession of meth. What's this? 6-4. All right, I also have another warrant for possession of a controlled substance in 2022 CF 6475. And that is based upon a warrant signed by Judge Laurent from January. So I'm going to stay the bond in that at the amount of $1,500. And I'm going to revoke her bond of $500 in 2022 CF 6483AO, which is in Division 17, for which she has a pretrial conference on July 5th. So I think that takes care of the three charges.
Your Honor, you mean the case she's on bond, the 2020 CF 13595AO? That's the case she's on bond for?
It is?
Yes. That's the case number, I think.
All right, I've got a division. I've got this warrant signed by Judge Dubois. I've got this warrant signed by Judge Laurent.
I only see 2 warrants and then an out on bond.
Yeah, I've got 2 warrants, and then I've got a sheet that tells me that she's out on bond on a third case.
Yeah, the case number's in the middle of the.
6483. Oh, so they've attached the Judge Laurent case, the Judge Dubois case. Six 4750 and 64830 and 6 and 13595. All right, what I think I see is that she's got 2 warrants and she's out on bond on another felony.
Correct, Judge.
Correct.
Okay.
All drug related.
All right. So I thought that unless I misspoke or was misunderstood, the one that she's out on bond on, the 13595.
Yes.
She's out on bond for $500. I'm revoking that bond. And then on the 2 new warrants, the 6483 and the 6475, I'm finding probable cause based upon the warrants and staying the bonds as contained in the warrants. $1,500 on the 6475 and $2,150 on the 6483. And to the extent that she's not already represented by the PD, I'll appoint the PD. I thought I had that right. Okay. Next I have Samaj Simpson.
We don't know yet. I think he said you don't confirm yet. Yeah, that's a big issue.
What happened with Simpson?
Mental health.
I will waive the appearance, Your Honor.
Actually, I'd like to just roll this to tomorrow.
Okay.
We'll just roll this to tomorrow. because it's complicated enough that I think she should be here. He should be here, she should be here, he should be here. So, Judge Bigney gets Mr. Simpson. All right, I have Quincy Smith. All right, so Mr. Smith is out on bond for possession of cocaine and possession of drug paraphernalia, and he's picked up a possession of meth, resisting an officer, and possession of drug paraphernalia. And he is a co-defendant for Chanthini Miller. I'm going to find probable cause. I'm going to stay the bonds as contained in the original charge, $1,000 on the meth, $100 on the resisting, and $100 on the paraphernalia. And I'm going to revoke his bond on the 2022 CF 6275 AO in Division 10. And to the extent that he's not currently represented by the public defender, I'll appoint the public defender in all cases he's not already been appointed on. Should he be released, I'll require he not have any contact with Chanthini Miller. No drugs, alcohol, possession of weapons, or firearms.
Co-defendant?
Excuse me, sir. Excuse me, sir.
All right, Marcella Stanley?
Can I say something?
You can say something, but it's not going to help you.
I'm just saying, man, my car is at 7-Eleven. I got the keys. I don't, you know what I'm saying? The police didn't even have proper calls. They didn't mess with me. It was a traffic stop. It was a traffic stop, and they just.
Okay, well, it's not going to change what I do. We do have a prosecutor that's taking good notes. So anything you say, they're going to use against you. So I would suggest you don't say anything else, as would your lawyer. I've set conditions of release. Good luck, sir. Marcella Stanley. All right, it appears as though Miss Stanley is here on a warrant. For aggravated battery on a pregnant person. Bond on that warrant is $50,000. I don't have any charging affidavit. State. This is on Marcella Stanley. Yeah. Do you have anything?
We filed information on it already, Your Honor.
Okay.
And I have the probable cause document. However, I don't have a printer in here.
Let me ask you. I don't know anything about it, and $50,000 seems like a pretty high bond. I do have a warrant, so I can find probable cause based on the warrant.
Yes, I believe with my reading, I read it earlier because that's not a standard bond for that charge. I believe it was potentially aggravated, or the judge has said it at $50,000, believed it to be aggravated, just because it seemed like a jumping situation at a Wendy's, where the employees of the Wendy's had to shelter her behind the counter. I believe she had to use weapons to try to defend herself. I believe there was mace that she had on her person. So I believe that potentially is why. And I believe she was significantly pregnant, like visibly pregnant, upon my reading of it earlier. And I believe there were multiple people involved.
Are you asking that I stay the bond at $50,000?
Your Honor, due to another judge reading it and determining that that was appropriate when looking at all the facts and the history, I would ask that you say it at this time. And if it is deemed unreasonable at a later time, the PD can file a motion for a bond motion to have it reduced.
Your Honor, I would ask that you consider reducing the bond amount in this case. My client, based on my reading of her face sheet, has no history. The only thing, I don't see any history. She's a military veteran, never been in trouble. I would ask that you, the bond amount, the purpose of the bond is to ensure one's presence for a court and protect the community. I don't see any other violent offenses in her history, and no failures to appear. So I'd ask that you consider reducing that bond amount in this case.
Ms. Fleming, I don't suppose you have a charging affidavit handy, do you?
I have the PC. I can approach with it. I don't have a printer.
30 page?
Yeah.
All right, this is what I'm going to do. This is clearly, there are facts here that I don't have access to, that the judge that signed the warrant had access to. I am going to find probable cause based upon that judge's warrant. This is reviewable by that judge on a bond motion that can be filed by the defendant's lawyer with notice to the state and an opportunity to be heard by the victims. So at this time, I'm going to stay the bond, but Ms. Stanley's going to have an opportunity to address this with the judge. Who's Division 16?
Barber.
Judge Barber? All right. And I'll appoint the public defender to represent Ms. Stanley.
Your Honor, so it asks for no contact, no weapons, and no return to the Wendy's.
That will all be, that is what is contained in the warrant, and so I will order no contact directly with the victim or co-defendant or witness, do not return to the scene of offense, no weapons or firearms, and I'll also include no alcohol or drugs. All right, next I have Ephraim Vasquez. Mr. Vasquez is charged with possession of cocaine and possession of drug paraphernalia. I do find from the probable cause affidavit there is probable cause for the charge of possession of cocaine and possession of drug paraphernalia. It also appears as though he's charged with no valid DL, an attaching tag not assigned. Interesting. All right. All right, so okay, same charging affidavit, different date. So charges were filed, it looks like the next day. All right, so where was I? On 2022 CF 6816AO, possession of cocaine, possession of drug paraphernalia, I'm going to find probable cause. Bond of $1,000 for cocaine, $500 for drug paraphernalia. And appoint the public defender. And then as it relates to the no valid DL in 2022 CT 3219, an attaching tag not assigned in 2022 CT 3220. I'm going to find probable cause and set bonds at $500 on each of those criminal traffic misdemeanors and appoint the public defender's office. That was confusing. Okay. Good luck, sir. David Avalo Nunez.
These are our Spanish.
Are we to Spanish now?
David Avalo Nunez is on the Spanish.
Okay.
Okay.
All right, so we'll need the interpreter, and I think that's done from not my end.
Your Honor, can we go back to Mr. Demetrius Oldham for the grand theft? He refused, and he did qualify for PTR.
Okay.
I'm going to defer to the court because he does have an extensive history. His last failure to appear was back in 21.
He also has a prior conviction for grand theft.
So if we can maybe just do the bond.
Now, was Mr. Odom there? We had him sit down? Is that what happened?
He refused.
We can reset her tomorrow, Your Honor.
Let's do that. It's a little too complicated for me to do this without him being there. So we're gonna reset that for tomorrow. All right, we'll come back to Mr. John Doe when we're done with the Spanish.
Good afternoon, Your Honor. This is Lavarius Spanish interpreter, previously sworn.
All right, good afternoon, Ms. Morales. We have first David Avalo Nunez. Mr. Nunez is charged with battery.
Al señor Núñez se le acusa de agresión física.
I find probable cause based upon the charging affidavit.
Determino que existen indicios de criminalidad según el documento acusatorio.
State, do you want to be heard on conditions or bond?
A la fiscalía le pregunto, ¿desea expresarse en cuanto a las condiciones de la fianza?
Your Honor, State, we just asked for the normal conditions.
All right.
Señoría, estamos solicitando las condiciones usuales.
All right, I will set bond in the amount of $500.
Muy bien, se concede fianza por la cantidad de $500.
I'll require that Mr. Avalo Nunez not return to the scene of the offense of 8820 South Orange Blossom Trail.
Se le prohíbe al señor Ávalo Núñez regresar a la escena del ilícito 8820 South Orange Blossom.
I will also require he have no contact with Devin Naylor, the victim in this case.
Se le prohíbe todo tipo de contacto con el señor Devon Naylor, la víctima en este caso.
I will require that he not consume alcohol or drugs.
Se le prohíbe el consumo de alcohol y drogas.
And not possess any weapons or firearms.
Y también se le prohíbe la tenencia de todo tipo de armas y armas de fuego.
And I'll appoint the Office of the Public Defender to represent Mr. Avalo Nunez.
Se designa la oficina del abogado de oficio para que represente al señor Ávalo Núñez.
All right, good luck, sir.
Buena suerte, señor.
Next I have, did you need the case number, Madam Interpreter?
Yes, if you have it.
I think I can help you out. Looks like it's 2022 MM 3951AO.
Thank you. That was Mr. Ávalo Núñez, right?
Sí.
Okay.
Joel Bueno Sardue. Something like that. All right, good afternoon, sir.
Buenas tardes, señor.
You are charged with failure to appear.
A usted se le acusa de falta de comparecencia.
On a charge of driving while license suspended or revoked.
Ante una acusación de conducir con la licencia suspendida o revocada.
The judge that issued the warrant set bond in the amount of $1,500.
El juez que firmó la orden de arresto concedió fianza por la cantidad de $1,500.
I'll stay the bond in the amount of $1,500.
Y la fianza permanecerá tal cual en la cantidad de $1,500.
It also appears that the defendant is currently out on bond from a case from January.
Este acusado se encuentra ahora mismo libre bajo fianza por un caso que se remonta al mes de enero.
And it appears that that charge is also driving while license suspended or revoked.
Una acusación también de conducir con la licencia suspendida o revocada.
I will revoke that bond.
Ron, what case number do you have?
Esa fianza se revoca.
2021 CT 396AA.
Este es el caso 2021 CT 396AA.
That's what he's here
Current
for.
case is 22 CT 1182.
That case was transferred from, okay, it says entry error. So that case is not,
It's open. It's a status hearing on 728.
Ese caso se transfirió, no está abierto.
All right, so do I need to take action on the,
is it citation?
Your Honor, state would ask for no action on the Audubon, given that the case is here for today is a failure to appear. It's not a new law.
okay. All right. Thank you, Ms. Fleming. I will take no action on the case on which he's currently out on bond.
Señoría, le solicitamos que no tome acción en el caso en el cual se encuentra actualmente libre bajo fianza, ya que él se encuentra aquí ante una falta de comparecencia y no un nuevo incumplimiento con la ley. Muy bien, entonces, así que no se toma acción en el caso en el cual se encuentra él libre bajo fianza.
And then, is the defendant currently represented by counsel on the case on which he failed to appear?
En el caso al cual no compareció a la audiencia, ¿se encuentra el acusado representado por algún abogado?
I see a PD, Your Honor.
Okay. PD is currently appointed and will continue to represent the defendant on that case.
La oficina del abogado de oficio se encuentra designada a este caso y ellos continuarán con la defensa del acusado en el mismo.
And then, Madam Interpreter, that case number is 2021 CT 396AA.
Thank you.
All right, next I have Inocencio Encarnacion Villegas. All right, sir, you are charged with operating a motor vehicle without a valid driver's license and driving under the influence of alcohol or drugs to the extent your normal faculties were impaired.
Muy bien, señor, usted se le acusa de conducir sin licencia válida y de conducir bajo los efectos de drogas o alcohol a un nivel tal que sus capacidades se encontraban disminuidas.
Based upon the charging affidavits of these two charges, I'm going to find probable cause.
Según el documento acusatorio, determinó que existen indicios de criminalidad.
I'm going to set bond in the amount of $500 on the no valid DL.
Se concede fianza $500 ante la acusación de conducir sin licencia válida.
And $1,000 on the DUI.
Y $1,000 de fianza en cuanto a la acusación de conducir bajo los efectos.
No, appoint the Office of the Public Defender to represent Mr. Encarnacion Villegas.
Se designa al abogado de oficio para que represente al señor Encarnación Vega.
And I'm going to appoint the Public Defender to represent him on both cases.
Este abogado ha sido designado para que les represente en ambas causas.
And Madam Interpreter, that's 2022 CT 585 and 586 AA.
Thank you.
Jorge Figueroa Rivera.
Bonded, Your Honor.
You bonded? Okay.
Yes, sir.
Thank you, sir. All right, next I have Lionel Guillen Triguera. All right, based upon the charging affidavit, I'm going to find probable cause.
Según el documento acusatorio, determinó que existen indicios de criminalidad.
I'm going to set bond on the DUI in the amount of $1,000.
Se concede fianza en cuanto a la acusación de conducir bajo los efectos, $1,000.
And the no valid DL in the amount of $500.
Y en cuanto a la acusación de conducir sin licencia válida, $500 de fianza.
And I'm going to appoint the public defender to represent him.
Se designa el abogado de oficio para que les represente.
And the case number, Madam Interpreter, is 22 CT 979 AW.
Thank you.
Next, I have Eric Rivera Coppin. Mr. Rivera Coppin is charged with carrying a concealed firearm.
Señor Rivera Coppin se le acusa de portar un arma oculta
And also petty theft.
y también de hurto de menor cuantía.
Having found probable cause, I'm going to set bond on the charge of carrying concealed firearm in the amount of $2,500.
Habiendo determinado que existen indicios de criminalidad en cuanto a la acusación de portación de arma oculta, la fianza será de $2,500.
And on the petty theft in the amount of $250.
Y en cuanto a la acusación de hurto de menor cuantía, $250 de fianza.
I'll appoint the public defender to represent Mr. Rivera Coppin.
Se designe el abogado de oficio para que les represente, señor Rivera.
Madam Interpreter, that's 2022 CF 6801A0. All right, do we have any other Spanish interpreter cases?
Nope.
All right, the last one I've got is Mr. John Doe.
I still haven't gotten a response, Your Honor.
Okay. Robin, what do you expect that your email is what information will that provide?
Hopefully we will get a name. I mean, he's here on the possession of counterfeit driver's license, okay?
Right.
And providing false ID. It says community ties were investigated with probing questions in Google Maps. So it looks like we may qualify him, but yet we're still waiting on the name. So if you just want to give him a bond, Your Honor, or
I'm really concerned about giving him a bond because we'll never get him back because we don't know who he is.
I'm just waiting for the name, his name.
Ms. George, do you have any suggestions?
Yes, Your Honor. My client stated he can provide contact information of where he resides and where he will be at, Your Honor, if that would help the court.
Does your client under oath want to tell us his name?
Yes, Your Honor. We have no problem doing that.
Okay, all right. Because he has the right not to tell us his name, but I can't move forward on his case till I know who he is. So he can volunteer to do that. I don't know if he's previously been sworn. Let's go ahead and swear him. Do you promise? Raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, sir. You're now under oath. You're charged with a couple of crimes. Looks like one is a felony and one is a misdemeanor. Would you tell me your name? Do you want to tell us your name?
Yes, sir.
All right, and what is your name, sir?
My name is Antonio Andre Ajuda.
Antonio Andre Ajuda, Adjudah.
Yes, sir.
That's the name that's contained in the charging affidavit. So we're going to use that name. Mr. Ajuda has under oath told us that's his name. Where do you live, sir?
I live with my sister.
Okay, what is your sister's name? I heard Brittany. Can you get a little closer to the microphone?
He said Brittany McKay, Your Honor. I don't know if you.
All right, Brittany McKay. MCKAY?
Yes, sir.
All right. And what address do you reside at with Brittany McKay?
5700 in Lakeside Drive.
Okay. 5700?
Yes, sir.
Okay, that's the address that's on the charging affidavit, and that's in what city?
Market.
Okay. Margate, Florida, and do you know the zip there?
It's 33063.
All right. And is there a phone number where you can be reached?
Yes, sir.
You want to tell us that number?
I can give you mine and my sister.
Okay, I have a number for you that he gave us.
All right. All right, I'm going to find probable cause. I've now identified you as something other than John Doe.
He wouldn't qualify for PTR, his legal status.
Understand. I'm going to set bond on the possession of a counterfeit driver's license in the amount of $2,500. Providing false identification to a law enforcement officer in the amount of $100. I'm going to appoint the public defender's office to represent you. Mr. Ajuda, your case is assigned to Division 12. So you're going to get paperwork as to when to return to see that judge. You're going to want to be certain you don't miss that court date, and you're going to want to keep in contact with your lawyer so that you follow all the rules of your release. I'm also going to require as a condition of your release that you do not drive without a valid driver's license. Okay, anything further, State?
No, Your Honor.
Anything further, Ms. George?
No, Your Honor.
Madam PTR?
So, Your Honor, what was the bonds, 2,500 and?
2,500 and 100. All right, anything else on Mr. Ajuda? All right, thank you, Mr. Ajuda, good luck. All right, so I see one assistant public defender and 4 court deputies, and I see no more defendants. Could it be that we're actually done?
Can I run some numbers by you?
All right, folks, thank you for your patience with me today. It did not go as smoothly as I had hoped. Better than I had feared. That will conclude initial appearances for today. Have a good afternoon.
Thank you, Your Honor.
Take care.
Thank you, Ms. George. Thank you for your help today. You did a great job. I appreciate it.
Thank you.
We are here today for initial appearances. When I call your name, I'm going to ask that you come up to the microphone. I'll ask you for your name and your date of birth. Make sure I have the correct person. I will also let you know what charges you've been picked up on, if there's a bond, and what that bond and its conditions are. For today's purposes and today's purposes only, public defender is appointed to provisionally represent you. If you need their services, you do need to complete an application and have it reviewed to see if you qualify. If you don't want their services, you simply just need to tell me that you don't want their services today, and we will move forward accordingly. May I have appearances starting with the state?
Yes, Your Honor. Matt Kazera from the state. That's
Thank you.
AOZYRA.
And pretrial release?
Patricia Jenkins, pretrial release.
And defense?
Alexander Rosa with the Public Defender's Office.
Thank you. First case, 2022 MM 897, Mitchell Constanza Fista.
Mitchell Feaster?
Yes?
I believe he refused, Your Honor.
All right, well, since he's refused, he's waived his right to have his initial appearance. Warrant was issued in 22 MM 897 for failure to appear for arraignment. There is a $5,000 bond. Next case, Eduardo Million Felix.
Your Honor, he's detoxing.
He'll be reset for when he is available. Daniel Waldrop?
He bonded.
Okay.
He bonded, Your Honor.
Thank you.
Also, we have 2 Spanish speakers, just so you're aware.
All right, well, when I get to them, let me know who they are. We won't have them come up yet. We'll do them last since I wasn't informed of that previously. Eric DeJesus.
My name is Eric DeJesus. My birthday is 09/22/1993, ma'am.
Thank you, sir.
Yes, ma'am.
Sir, you've been picked up as a result of a couple of matters. The first one is an arrest warrant for fleeing and eluding law enforcement officer with lights and sirens activated. Probable cause was found when that warrant was issued. I have, however, reviewed it and I concur with the finding. Bond to be set on this case in the amount of $1,500. You also have failure to obey law enforcement officer's order to stop and driving with license suspended as an equivalent status. Court has reviewed that charging affidavit. I do find there's sufficient probable cause. Bond on count 1 will be set in the amount of $1,500. Count 2, the amount of $500. Do not drive without a valid Florida driver's license. Additionally, it appears that you are on ROR for 22 CF 2339. The court will be revoking and setting it 0. Thank you.
Sorry, Your Honor, what was that case number? The
22 CF 2339.
Thank you.
It's out of Orange, counsel.
Oh, I see.
Patrick Gordette.
Patrick Gordette, date of birth 12/01/1977.
Thank you. Sir, you've been picked up as a result of battery, simple touch, or strike associated with a domestic battery. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be in the amount of $500. You are not to return to 2065 Shannon Lakes Boulevard. You're to have no contact with Jennifer Gordette. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
Thank you, sir.
Your Honor, Mr. Gordette has a family member here, not a victim, but just a family member who apparently has a place for him to stay. I don't know if you wanted to hear from him. Also, the state in all domestic violence cases asks for no weapons, no firearms while on release.
I mean, I didn't see anything in the affidavit about a weapon or firearm.
I understand, Your Honor.
Okay. I won't be ordering that.
For that one?
$500. So he's going to be able to come stay with you?
Yes, ma'am.
What is your name?
My name is Anthony Victor.
Anthony what?
Victor.
Victor?
Yes, ma'am.
All right, so sir, when you get out of jail, you can go stay with Mr. Victor, okay? Thank you. Thank you, Mr. Victor. You don't have to stick around if you don't want to.
Excuse me, Your Honor?
Yes,
Can
sir.
you get a number from Mr. Victor for him to call? He doesn't have a cell phone on him. He needs to contact him.
Yes.
Mr. Victor, what's your number?
It's 321
Can you hear him, counsel?
I cannot.
321
443
443
53
5324.
Thank you, Your Honor.
You're welcome.
Is there anything I can say about him that for his behalf?
I've given him a quite low bond, to be honest with you.
Okay, no problem.
All right, but thank you for being here, sir. Sean Jewell.
He's detoxing, Your Honor.
All right, he'll be reset for when he is available. Ivan Morales Gordo. Good afternoon, sir. State your name and date of birth, please. Thank you. Sir, you've been picked up as a result of child abuse without great bodily harm, battery, touch, or strike, and intent to threat to do violence. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause as to each charge. Bond to be set on count 1 in the amount of $1,000, count 2 the amount of $1,000, count 3 the amount of $500. You're not to return to 850 Perth Place, apartment 101. You can go back one time with the assistance of law enforcement to obtain your personal items only, but only with the assistance of law enforcement. You're to have no contact with I'm not really sure how to say that. Janitza? Okay. Jonitza Vasquez, Julian Mantretti, or Melanie Morales. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand? Is that a yes? Yes. Additionally, you're to have no alcohol, no drugs, and you're not to possess any weapons or firearms. Additionally, you've been picked up as a result of a resisting arrest without violence. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. Bond to be set in the amount of $500. Thank you. Leanne Jones. Good afternoon, ma'am. State your name and date of birth, please.
Leanne Jones, June 1st, 1989.
Thank you. Ms. Jones, you've been picked up as a result of battery simple touch on a victim 65 years of age and older in a domestic situation. Does anybody wish to be heard on this case?
Yes, Your Honor. Excuse me one second. Can we recall this one? Because I need to find the police report. I misplaced it.
No, counsel, go ahead and find it now, please.
Okay, Your Honor, in this situation, I believe there's no probable cause because the defendant did not, there's no probable cause to believe that she intentionally shoved the victim and also did not know the age of the victim.
State.
Yes, Your Honor. I'll note on the third full paragraph on page 2 of the affidavit, about halfway down, it starts with, while outside the residence, the victim stepped out of the residence, advising that the subject had pushed her. I obtained a sworn witness statement from the victim. It said that while in the hallway between the living room and the kitchen, the suspect walked next to the victim and shoved the victim with her shoulder. The suspect told her it was an accident, but it seemed to be intentional due to the size of the hallway. The law enforcement officer had been inside the home earlier and knew the layout of the home, was able to evaluate the credibility of the witnesses, was able to evaluate the credibility of the statements, and decided to believe the victim and to disbelieve the testimony of the suspect. So there was probable cause for a finding of a battery. I will note that the age of the victim is stated in sort of a conclusory fashion down towards the bottom. It's the last multi-line paragraph there. It says the suspect made threats to the victim and then intentionally shoved the victim, who she knew to be 67 years old. So while I agree that it is somewhat conclusory, I do believe that the probable cause affidavit is sufficient for finding a probable cause.
Your Honor, if I may also add, the alleged victim in this case is also the legal guardian of the defendant as well.
Oh, well, that doesn't make any difference in this case today.
Just letting you know, Your Honor.
Thank you. All right, the court's going to find probable cause as to the charge that Ms. Jones was arrested on. It's pretrial release with a bond. The bond will be set in the amount of $500. Ms. Jones is not to return to 1534 Jason Street. She can go back one time with the assistance of law enforcement to obtain her personal items only. She's also to have no contact with Enid Jones unless it is in a court-related proceeding and only related to the guardianship. Thank you. Jonathan Olmo Padilla.
That's a Spanish speaker, Your Honor.
Can you tell me who the other one is? I'll go ahead and pull them out now.
Yeah, it's Ubrina Reyes Wilmer.
All right, well, since Mr. Padilla is not coming up, we'll just go ahead and take him last. Oh, I guess he is gonna come up now.
Hello, Cisco Unity Connection Messaging System.
Counsel, if you just have him take a seat, we'll have to recall it. Rayford Powell. Good afternoon, sir. State your name and date of birth, please.
6272.
And your name?
Rayford Powell.
Thank you. Mr. Powell, you've been picked up as a result of trespass after warning. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for direct pretrial release. The court will grant that. Part of your conditions is that you're not to return to 4400 13th Street. That is the St. Cloud Walmart. Do you understand?
Yes, ma'am.
Thank you, sir. Jose Rosado.
Jose Rosado, 6/27/1999.
Thank you. Mr. Rosado, you've been picked up as a result of possession of a counter title registration as well as possession of a counterfeit license plate. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond on count 1 will be set in the amount of $1,000. Count 2, the amount of $1,000. With regard to 22 CF 1098, it appears that you're out on pretrial release. The court will be revoking that and setting it at 0. Thank you. Carl Schubert.
He's in the cage, Your Honor. One moment.
Thank you. What's your date of birth, Mr. Schubert?
7/83.
Thank you. Mr. Schubert, you've been picked up as a result of trespass on property. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. You do not qualify for pretrial release. However, I'm going to ROR you in this matter with the condition that you are not to return to 1095 Cypress Parkway. That is the Wawa. Do you understand, Mr. Schubert?
Yes, I do.
You understand that you end up back there and the police are called, you're going to be picked up again, and it might not be an ROR again.
Yes, I do, man.
All right. Thank you, Mr. Schubert. Have a good day. John Wolf.
Yes, ma'am.
State your name and date of birth, please.
John Wolf, 31067.
Thank you. Mr. Wolf, you've been picked up as a result of battery, domestic by strangulation. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You do not qualify for pretrial release. Bond on this matter will be set in the amount of $2,500. You're to have no contact with Rayanne Yarwood. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand? You're not to possess any weapons or firearms. You're not to possess or consume any alcohol or drugs except any prescription drugs in which you're permitted to take them as prescribed. Do you understand?
Yes, ma'am.
Mr. Wolf, I do have a question for you. In this affidavit, it said that she was coming back to retrieve some of her belongings. Does she not live there anymore?
She does not. She only stays here or there. Here and there because I got chemo and all that to do.
State or pretrial release, do we have any information about that?
I don't have any, Your Honor.
No, ma'am.
All right. Well, Mr. Wolf, at this time, I'm not going to allow you to go back to 1116 Oregon Avenue until we can flesh out whether she's living there or not. If it turns out that she's not living there, the attorneys can file a motion on your behalf. You can go back one time with the assistance of law enforcement to obtain your personal items, including any prescription drugs that you have. Thank you. Alice Matheny. Good afternoon, ma'am. State your name and date of birth, please.
Alice Matheny, 7/2/1982.
Thank you. Ms. Matheny, you've been picked up on a couple of matters. One of them is violation of probation or community control in case number 21 CF 3111. The warrant was issued in that matter. There's no bond. Additionally, there's possession of cocaine, possession of controlled substance without a prescription, to wit heroin, possession or use of drug paraphernalia. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause as to all three charges. Count 1, bond will be set in the amount of $1,000. Count 2, bond will be set in the amount of $1,000. Count 3, bond will be set in the amount of $500. You're not to possess or consume any alcohol or drugs. Do you understand?
Yes, ma'am.
Thank you. Chase Causey.
Your Honor, I'd like to request the waiving of the reading of the charges in this one.
Yes, sir. Good afternoon, sir. State your name and date of birth, please.
Chase Charles Causey, 11/10/73.
Thank you. Mr. Causey, do you know all the charges that you've been picked up on?
No, ma'am.
Then take a moment and review them with the attorney, please.
Your Honor, just for the court's awareness, I do not have probable cause affidavits for any of Mr. Causey's cases. I'm not sure why they didn't make it over to me.
Oh.
Yeah, it was I didn't even have it. It was an add-on, but I'll print it. Because I didn't have a case.
Thank you.
Really think you're going to need them, though, counsel.
That's fine.
We're ready,
All right.
Your Honor.
Mr. Causey, you have the opportunity to speak with the attorney.
Yes, ma'am.
Do you now know what the charges are that you've been picked up on?
He read them to me. I'm right now, ma'am, I'm not really aware of what's going on.
All right, Mr. Causey, he has asked me to waive the reading, which means he's asking me not to announce what the charges are. Do you feel comfortable moving forward if I don't announce what they are?
Yes, ma'am.
All right. Court has reviewed the charging affidavit. I do find there's sufficient probable cause as to all of the charges. Bond to be set on count 1 in the amount of $10,000. Count 2, the amount of $5,000. Count 3 will remain at 0. Count 4 will be at $3,000. Count 5 at $250. You're not to have any contact with Veronica Blandon. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
You are to abide by the terms and conditions of the injunction. You also note that you are on probation for 22 MM 135. Court will be doing an on-view violation and setting your bond at 0. Thank you. Oh, did I miss some? Hold on, I'm not done yet. Ugh. I don't know why they separate them like that. As to the second set of charges, court has reviewed the charging affidavit. I do find there's sufficient probable cause. Bond on count 1 be set in the amount of $10,000. Count 2, the amount of $1,000. No contact with the victim, Ms. Blandon. Abide by all terms and conditions of the injunction. Finally, as to the third set of charges, the court has reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond to be set on count 1 in the amount of $1,000. Count 2, the amount of $500. You are not to possess or consume any alcohol or drugs. Thank you. Counsel, that takes care of all of his charges.
Thank you, Your Honor.
Justin King. Good afternoon, sir. State your name and date of birth, please.
Justin King, 11/5/1989.
Thank you. Mr. King, you've been picked up as a result of carjacking, robbery. Are you good? All right. Carjacking, robbery with no weapon, burglary, assault or battery, forced entry, battery, simple touch or strike, and criminal mischief. Court has reviewed the charging affidavit. I do find that there is sufficient probable cause. Bond to be set on count 1 in the amount of $20,000, count 2, $5,000, count 3, $1,000, count 4, $1,000. You're not to return to 1598 13th Street, that is the bakery, and you're to have no contact with Derek Victoria. Additionally, you are not to possess any weapons or firearms. Do you understand? Yes, sir. Thank you.
Your Honor?
Yes, sir.
I'm sorry, this is another one that I did not have. Would you permit me just a quick moment to read over it? I note that a couple of the charges are first-degree felonies punishable by life, and I don't know whether the state's going to be asking that he be held no bond.
No, go ahead, counsel. You can take a few moments to review.
Your Honor, I appreciate it. I'm just pulling it up off the clerk's site.
Did you say $5,000 on count?
I said 20,000, 5,000, 1,000, 1,000.
Oh, so you, okay.
Are you cold? Ah.
All right, thank you, Your Honor, for your patience. The state would ask that that Mr. King be held without bond on count 2, burglary with an assault or battery, forced entry, under Florida Statute 10.02, Section 2A. I believe that's the only one that is a first-degree felony punishable by life in prison. Under the new guidance from the Supreme Court, the court only needs to find probable cause at initial appearances, and then the division is responsible for setting an Arthur hearing.
All right. Defense, do you have any response as to count 2 being at 0 bond? I mean, I'm not doing an Arthur hearing today. Let's be clear about that.
No, Your Honor.
Okay. Then count 2 will be set at 0, pending a hearing by the trial judge. Monique Wolf. So there's a note on here that this was reset for PC. Good afternoon, ma'am. State your name and date of birth, please.
Yes, good afternoon, Judge. My name is Monique Wolf, date of birth 10/14/1972.
Thank you. State, I'm kind of looking to you because I don't know why it was reset for PC.
Judge, and I'm not sure, the last like 5 cases that you've called, I did not have. This is another one that I did not have. This is 22 CF 1706, is that correct?
Yes, sir. The note on it from this weekend is court resets in regards to PC. And the reason I'm questioning it is because on the face of the affidavit, I believe there to be PC, so I'm wondering what I'm missing.
Well, Judge, I have not received any supplements on the case, so whatever we have in the record is going to be what we have in the record. Let me pull up the affidavit quickly. And Madam Clerk, can you tell me whether these were all add-ons?
No, they were resets. They were with the report that we sent this morning, yeah. The only one that was an add-on was Matheny Alice.
Right.
She was reset from last week.
Yeah, but they didn't send me the paperwork with, so they sent me a different email.
Defense, do you have any information about why this was reset?
I do not, Your Honor. I'm reading the report right now, but I don't see any specifics.
I don't see any reason that it would have been reset based on my
Saturday, so I
review.
wasn't there, so I don't even know.
Judge,
Okay. Your Honor, I believe that it has something to do with the vehicle not being an auto. It was a golf cart, so it was reset for those purposes.
But a golf cart can be an automobile. You can actually get a DUI in one.
Didn't know that, but a
You
lot of
can.
them are called conveyances in other cases, not autos, from what I've seen.
State, do you have any response to that?
Well, Your Honor, Florida Statute 316.003, I believe is the operative, it may be 320.01. Motor vehicle means, let's see. Oh boy, this is an extensive definition with 8 subparts, Judge. But it is an automobile, motorcycle, truck, trailer, semi-trailer, truck, trailer, or semi-trailer combination, or any other vehicle operated on the roads of the state that's used to transport persons or property and propelled by power other than muscular power.
All right, so no Fred Flintstone cars.
No Fred Flintstone cars, Judge, and has to be operated on the roads of the state.
All right, well, I'm going to find PC for both counts then, based upon that definition. I presume that's why the weekend judge reset it, but I'm not going to assume anything. That's why I was inquiring. Bond to be set on count 1 in the amount of $5,000, count 2 the amount of $2,000. Ms. Wolf, you are not to return to Treasure Trove Lane. Do you understand?
Yes, ma'am.
Thank you. That's it. Let's see if we can get an interpreter.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Good afternoon, Mr. Arroyo. We are in Fort Echo and Osceola. We are doing initial appearances, so I will be piping it through the courtroom over to the jail. Our first case up is 22MM1319. Jonathan Olmo Padilla. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento.
Jonathan Olmo, 1208 del 79.
Despacio, fecha.
Diciembre 8 del 77.
Jonathan Olmo Padilla, December the 8th, 77.
Sir, you've been picked up as a result of possession or use of drug equipment.
Bien, señor, usted fue detenido por tenencia o uso de equipo de drogas.
Court has reviewed the charging affidavit. I find there's sufficient probable cause.
He estudiado el affidavit inculpatorio y determino que existe suficiente indicios de criminalidad.
Bond to be set in the amount of $500.
Se fijará la fianza en $500.
You're not to have any alcohol or drugs.
Prohibido consumir ningún tipo de alcohol o drogas.
With regard to 22 CF 1134, court will be revoking the bond and setting it 0.
Con respecto al caso 22 CF 1134, se revoca la fianza y se fija 0.
Thank you, sir. You may have a seat.
Gracias, señor. Puede tomar asiento.
Next case, 22 CF 1703, Wilmer Urbina Reyes.
Your Honor, I would like to request the waiving of the reading of the charges in this and make a probable cause argument.
Su señoría deseó hacer constar que se renuncia a la lectura de los cargos con respecto a esta acusación y pido poder plantear argumentos de suficientes indicios.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento.
Wilmer Ernesto Urbina Reyes,
Fecha de nacimiento.
16 de enero de 1987.
Wilmer Ernesto Urbino Reyes, January 1687.
And sir, do you know what charges you've been picked up on? Yes or no?
Señor, ¿acaso sabe usted cuáles son las acusaciones por las cuales le han detenido? ¿Sí o no?
Específicamente no sé bien, pero tengo una certidumbre, pero no lo sé muy bien.
Specifically, I don't know it quite for sure. I have an idea, but not quite for sure.
All right, well, the attorney has asked that the reading of the charges be waived.
Es que el licenciado ha solicitado que la lectura de los cargos sea renunciado.
I need to be comfortable that you understand what the charges that you were arrested for.
Pero yo me tengo que sentir segura con respecto a si usted entendió las acusaciones por las cuales le han detenido.
No.
No.
Yes, sir.
¿Se me permite un momento para consultar con él? Sí.
Your Honor, I also don't have a copy of, I don't know what happened today. I don't have a copy of this, and it's not on benchmark.
You want to approach?
Thank you, Your Honor, very much.
That is weird, though. Happened in a lot of them.
I got a digital copy that doesn't have it, and I got paper copies that don't have it.
It's weird.
Should be all ready now, Your Honor.
All right, sir, did you have the opportunity to speak with the attorney?
Señor, ¿ha tenido usted la oportunidad de poder consultar con el abogado?
Sí.
Yes.
Do you now understand what the charges that you've been arrested for?
¿Ahora está entendiendo las acusaciones por las cuales le detuvieron? Yes.
Counsel, you said you had a probable cause challenge. Keep in mind we have an interpreter, so you'll have to pause.
Licenciado, usted dijo que tiene argumentos con respecto a indicios suficientes de criminalidad que plantear. Por favor, tenga en cuenta que tenemos aquí un intérprete.
Yes, Your Honor. This case was reset over the weekend, and to my knowledge, the charging affidavit still has not yet been amended. There does not include an age for the victim on it, therefore there should be no probable cause for the charge.
Sí, su señoría, este caso fue aplazado del fin de semana y tengo entendido que con respecto al documento acusatorio todavía no se ha realizado ningún tipo de modificación. En ello no consta todavía la edad de la víctima, por lo tanto pensamos que no existe suficiente indicios.
State, did you have the opportunity to review the affidavit?
La Fiscalía ha tenido la oportunidad de estudiar ese affidavit.
Your Honor, I am just finishing reading it right now.
Estoy por terminar de leerlo.
I agree with the defense that this affidavit does not allege the age of the victim.
Estoy de acuerdo con la defensa con respecto al hecho de que este documento no indica la edad de la víctima.
I will note that there are several circumstantial indicia of the age of the victim.
Sí haré constar que tenemos aquí varios indicios circunstanciales con respecto a la edad de la víctima.
One is the fact that the victim was spoken to by a CPT case coordinator.
Uno de ellos es que uno de los técnicos de la unidad CPT habló con la víctima.
One is the fact that the victim was not sworn but was instead truth qualified.
Uno de los otros es que la víctima no prestó juramento, sin embargo se determinó que cualificaba al entender la verdad.
One is the involvement of the Department of Children and Families in the case.
También que participó en este caso el Departamento de Familias y Menores.
That being said, I do not have any indication in here of the date of birth of the victim or of the age of the victim, except, I'm sorry, go ahead, Madam Interpreter.
De todos modos, no tengo aquí ninguna indicación con respecto a la fecha de nacimiento o la edad de la víctima.
Other than the second to last paragraph, which concludes the age of the victim.
Excepto que en penúltimo párrafo hace una conclusión con respecto a la edad de la víctima.
Your Honor, I have no information about any modifications or amendments to this paperwork that had been requested.
Su señoría no ha recibido información alguna con respecto a cualquier modificación o cambio a la documentación que se solicitó.
Given the circumstances of the case, I would ask for another opportunity to get a supplement for the court's consideration.
Siendo así, solicito la oportunidad de conseguir documentos suplementales con la edad de la persona indicada.
But at the very least, I would ask that the court find probable cause for a battery, which does seem to be supported and is a lesser included offense.
En lo mínimo, solicito que se determine que existe indicios de criminalidad con respecto a la acusación de agresión física, lo cual es un indicio subsumido, sustentado en la causa.
And I would ask for appropriate conditions upon his release, if the court were inclined to do that.
Y si su señoría estaría dispuesto de concederle libertad, pido que se impongan condiciones apropiadas.
Your Honor, I would object to another reset, considering the state has already had an opportunity to amend it.
Su señoría, yo protesto a que sea aplazado nuevamente, ya que la Fiscalía ha tenido suficiente oportunidad para hacerlo y se fijó para el calendario de hoy.
The court will reset for an additional 24 hours. It's in my discretion to do so.
Se aplazará por unas 24 horas adicionales. Esto cae dentro de mi discreción para hacerlo.
State, if you can get an update as to an identification of the actual age of the child.
Yes, Your Honor.
¿Será actualizado con respecto a la edad específica del menor?
If not, then I'll just be finding probable cause as to a child.
I'm sorry, Your Honor, could you repeat the last part? Probable cause as to the child, is that what you said?
As to a child.
Si no es así, se emitirá un fallo de que existe suficiente indicios de criminalidad con respecto a que hubo un menor de edad.
So it'll be reset for tomorrow.
Por lo tanto, se aplazará esto para mañana.
Thank you, sir. You can have a seat.
Gracias, señor. Puede tomar asiento.
Counsel, did we get everyone over there?
Mati Carry-On, said he was an add-on from PTR, I believe.
Oh, because I don't have any paperwork.
I didn't get any either, Your Honor.
Yeah.
So it's been a mystery to me as well.
We didn't get it, and they know it.
Oh, well,
We said tomorrow.
I guess he'll be reset for tomorrow. Thank you. Thank you, Mr. Roa. Have a good day.
You're welcome, Your Honor. The interpreter will disconnect.